Laredo, Texas time. Let me put my lights on a little brighter. And we're waiting for the court to come back. They said at 1, but we know that normally that would mean 20 past, half past, something like that. But it's okay. We'll be patient. They're on Laredo time. Thank you to everyone who's reminding the chat that we're here for Grizelda and Dominic, for justice for them. Joy says, thinking about the Hernandez family. Exactly. Thank you so much. If I missed any members joining or stickers while I was away now, thank you so much for those. I will check them afterwards as well. Welcome, Amy Shore. Damn, DG says Boba Tea finally arrived in my town. You're so lucky. You know I love Boba Tea. Okay. And PT Notaman, is this for Dieter? Thank you so much. People are like, who's Dieter? You got to go to my second channel to see. So welcome, everyone. This afternoon, the judge said this would be quite lengthy. I think the defense is bringing a Dr. Campbell, is that? No, wait. What are the doctor's name they're going to bring? They're going to bring someone to the stand. It was Dr. Howard Campbell earlier, right? And so we shall see who the defense's witness will be. The state has rested. So this would be the second time. Remember, in phase 1, the state rested their case. We're now in phase 2 of the trial, penalty phase. And again, the state has rested their case in this phase. So here we are, getting closer and closer to the day where the jury will be deliberating. And they'll be deciding if Burgos will get the death penalty or not. There we go. Cunningham, says Paige Willow. Good job. Okay, I was like, Campbell? Cunningham. Okay. And I think Dana Sarkis should also be back sometime later. She was the lady that works at the Webb County Jail, and she reviews all the inmates' communications, right? Yes. So people asking what's my second channel. Mods, if you're here, if you can drop that. Or, guys, just go to grizzlytruecrime.com. If you go to my About page and scroll down, you'll see it there. All my stuff is there. Even my hubby's channel, Sakura Aviation, is there. Yes? Mandy says, I love the sister and mother. Even through the tears and obvious pain, you can see this family is full of loving humor. Yes, indeed. And thank you so much, everyone, for sharing the purple hearts, white ribbons, and the baby Yoda. We're doing this for the family to show them we love and support them. They were wearing purple in court, and they also wear white, which is why I switched it up as well to wear purple and white to show them non-verbally, yes, we support you, we got your back. And also the baby Yoda is for Dominic. He was wearing a baby Yoda shirt in one of the videos we saw, as well as he was murdered wearing that shirt, which is just so sad. So if you are new here, for everyone who's here every day, you might be like, oh man, she's going to do the little recap again. Well, yeah, there's a lot of new people that are only now starting to catch up with the trial, only now starting to watch, or they might be curious, like, oh, I see there's something live is happening here. What is this about, right? So I give a little recap every time. And this is the case against Ronald Anthony Burgos-Aviles, a former Border Patrol supervisory officer. You might remember that last year, another Border Patrol agent was sentenced to life without parole, and he was actually a serial killer, and his victims were all sex workers, and his name was David Ortiz. So if it sounds, familiar, like, Laredo, Texas, Border Patrol, there was another case. This is about Ronald Anthony Burgos-Aviles, who was 28 years old at the time of the crime. He's 33 now. He's been in the Webb County Jail this entire time in protective custody, okay? And when the jury found him guilty, like unanimous guilty verdict before the penalty phase, he was actually moved to another cell and complained about it. Like, he's like, I don't want to move to another cell. Oh man, as if he gets to complain. Don't worry, enjoy your little cell, because you're going to be going either to death row or life without parole soon. So anyway, he was 28 years old at the time of the crime. That was on April 9th of 2018. And he murdered an ex-girlfriend, Grizelda Hernandez, and their son, because he got her pregnant, their son, Dominic Hernandez, 18 months old. It is horrendous. He stabbed Grizelda 27 times and Dominic twice. And he lured them there to an area, like, think about this. Think about how smart not this guy was. He lured them to an area that they knew well, but an area that he supervised as a Border Patrol supervisory officer. Lure them there, park the car at the Father McNaboe Park, and they walked towards him. We didn't see those messages. Someone asked earlier, did we ever see how he got Grizelda to, put Dominic in the stroller and walk towards where he was, which was like in nature? But that was Snapchat messages, which disappear after some time. So they did tell us the timestamps of the Snapchat messages. The last one was at 9:44 a.m. that Grizelda had sent. And so they believe she was murdered between 9:46 a.m. and 10:10 a.m. And then Dominic as well. But yes, he was so not smart that he lured them to this area that he supervised. He then took their phones, because Dominic had a little phone to play with as well. And we saw that on one of the videos of him holding the phone. He was so cute. And took their phones, put it in his Border Patrol truck, went home, was seen on the neighbor's camera in shorts and tennis shoes, came out in uniform. Okay, so he went home to change, basically. That's what I'm saying. And then went back to the scene, but drove so fast from that World Trade Bridge, right? And Border Patrol agent Dennison saw him, and he's like, what are you doing? He's like, I'm just exploring. Just exploring. Only to then go to the area where the victims' bodies were and discover them. But discover only the lady, according to him, which was Grizelda Hernandez. And then he called for an ambulance. And then he really thought he's going to get away with this. But within 1 hour, he was detained. Then he was interrogated. Then he was arrested and charged with 2 counts of capital murder. Jojo Lynn, welcome to Grizzly $2 supporter. Now I'm behind on the messages again. Sorry about that. Marilise, thank you for your $1.99 sticker. I'm trying to put it on the screen. YouTube is just not working with me. Hold on 1 second. There we go. So that was a little recap. I hope that you will check out some of the replays of the trial, because there were some excellent witnesses throughout this trial, and everything's been time-stamped for you. Let me just put this on here. Here they go. Are they coming back? So you can check out all the timestamps, all the key moments. You could also add some timestamps if you want in the comments. If you don't know how to do that, just check the format of how I write it. And if you write it like that, like at 47, minutes or whatever, this happens. You can also do that. Jane said, senior short. You mean on my other channel? The Burgos Booger Boy Snot Corp. Yeah. Yes, indeed. Jet says, I like G's recap. Sometimes I hear something I didn't hear before, and sometimes I'm too busy like yesterday that I missed stuff and I'm lost. It's my pleasure. Yeah, so once Burgos had called it in over the Border Patrol radio for an ambulance, Agent Lara was on scene as well. He was very close by, and he called him to come over, and he was trying to help. And then Burgos's P-brain started calculating, wow, okay, this could actually make as if he was the one who did this, or random smugglers. Wow. So anyway, and then we've also heard from Detective Reyes, Detective Raimundo Garcia. Remember, he made that whole compilation. That was brilliant as well. And just everyone that arrived on scene, including Officer Joshua Nunez, who's actually Grizelda's cousin, and he was on the scene, and he was the one to identify the bodies. That was horrible for him. He told us, right? Maria, welcome to Grizzly Super Supporter. Welcome. YT is a YouTube grandma. Coffee, tea, and cat treat fund. Thank you so much. And to Dana, earlier when I ended that live stream, I saw later you had bought a sticker there. To Dana Bulbrook, thank you so much for the treats for Fury as well. Well, we can hear some court sound, and as I say, it's almost past. I'm telling you. I'm getting accurate with Laredo time. I know I could speak their language now. With what time is it? 1 o'clock, 1:02. Steph McGarry, welcome. Roxanne says he has sociopathic traits. If a psych is taking the stand next over Zoom, if they don't say it, it's a defense paid witness. Okay. Flute, we are live too now. What do you mean? Thank you, Flute, for the sticker. We are live. So, KC Cat says, Grizzly Crab, do you think it would have been made a difference if he hadn't been the one to find the bodies? I do think so. Thankfully, he was too dumb for that. I do think it could have, although he had the victim's phones with him, and there was blood on the back of the truck. So, I don't know. Let me just refresh this page quickly. Just give me a second. We shall refresh it for anyone who's doubting anything. There we go. Boost it. We're going to boost the sound now. And I'm going to put it back on. Okay. So I do think, to answer your question, sorry, I do think it could have made a difference, but he's such a control freak. He needed to be the one to go back there. And I think he actually wanted more time to stage the scene as if it was smugglers or, you know, someone across the border that attacked them or something. But Agent Lara was in the area training someone else. So, yes. Regina says he would have been arrested in 2 hours instead of 1, right? So we saw the judge's head for about a second there. 1 second or so. Yeah. They were there for a second and that's it. I just want to have a sip of this. This is my Grizzly Ride or Die cup. With some rose tonic. Thank you to everyone who's buying coffees for the mods. That's so nice of you guys. Suzanne says, I think he was planning to deal with bodies, but Lara interrupted. Yeah. Probably because he was so close to the riverbanks as well. Yes. Okay, well, let's play our intro, shall we? Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Welcome back to day 11, afternoon session in the Ronald Burgos-Aviles trial. We are waiting for court to start. Jill said their love as a family was his biggest demise. I agree. Yes, he really underestimated Grizelda's family. It's actually ridiculous. This guy was so ridiculous, on my word. So Christine Barba says, why would he lure to his area though? To control every aspect of it, because he knew the area well. And he thought he was being really, really smart. Chela Mejia, thank you so much for your $2 super sticker. Thank you, I really appreciate it. Rose Marie J says, thank you, G, for all the hours of dedication and hard work you do to present this trial. And all you do for all of us. Thank you so much. Okay. And so we saw the judge pop up for just a second, you know, just about 2 minutes ago. So there's... There's activity in the court. Maybe they're waiting for the jury to come back in, which always takes quite long as well. I'm not too sure why. Take a while to get back in the courtroom, you know? But, yes. Oh, interesting. This is a good question for anyone who's local. Are there crocodiles in that area? Are there? Let's go Rio Grande, right? River. Laredo, Texas. Okay. Crocodiles. Let us look for the answer. are the alligators? There have been some unconfirmed reports of crocodiles near the coastal part of the Rio Grande. So they could be. They actually could be. I think that was his plan. It was either going to be that or really staging the scene and, you know, making it look like somebody else did it. There is the judge. Hi, Judge. Judge Joe Lopez. Yes, deep breaths and coffee. Very nice. With his Texas Cowboys cup. Okay, audio is boosted. Clarity, the visuals. I made the colors boosted for you too. And off we go. Oh, Susan, Texas. Nope, lots of snakes. Interesting. Yes, Beaver says, in the game, we know this truth. The jails are full of idiots that thought they were smart. Yes.
Okay, thank you all. Please have a seat. Good afternoon. We're getting started with our next witness. Will the defense please call your next witness?
Your Honor, at this time, the defense calls Dr. Mark Cunningham to appear via Zoom.
Very good.
Dr. Mark Cunningham.
We will get Dr. Cunningham spotlighted. And, well, I'm kind of wondering if I should spotlight you as well.
Okay.
Just so that he can see you. Can you see him bigger, Dr. Cunningham?
I can, thank you, Your Honor.
Okay. And we'll try and, you know, well, try our best to make sure that there's little confusion. We can't guarantee no confusion, but we'll try and minimize the risk of that with this environment. Okay, so Dr. Cunningham, will you please raise your right hand so that we could swear you in? Go ahead.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Very well. Thank you, sir. Please, you may begin.
And please.
Oh, wait a minute. Can I get the round mic over there? Or? Okay, you're good. Thank you. Just take it out of your hidden area there if you can. Just put it up here in the end of the table, sort of. That's good. Thank you.
Lone Star Lady says, I live in South Texas. They absolutely can be alligators. Interesting.
And that mic, of course, the table mic is for the round mic is for Dr. Cunningham to hear, so that we can hear him. And the big mic is so that we can hear the rest of the courtroom. I mean, the long, what do you call that? The unit mic? We got my T guy. Okay, let's proceed.
And for the record, would you please state your name?
Mark Douglas Cunningham.
And Mr. Cunningham, what do you do for a living?
I'm a clinical and forensic psychologist in private practice and also an independent research scientist.
And you said a clinical psychologist, is that correct?
That's correct.
And do you have a specialized area of psychology?
So I'm trained as a clinical psychologist, which is the evaluation and treatment of psychological disorders. My practice now is focused in bringing those clinical capabilities to bear in court-related cases, what's called forensic psychology. Forensic psychology is any way that psychology as a science can be helpful to some issue that's before the court. Within forensic psychology, I focus on criminal cases. Sometimes I do a civil case, but primarily criminal cases. And within criminal cases, I do a lot of different evaluations. I have a particular scholarly and research focus in sentencing evaluations and in factors that inform those sentencing evaluations.
So I've marked what is Defendant's Exhibit 13, and you have provided me your curriculum vitae?
I have. I think the current edition of them. It's a fancy word for a resume. I think it's dated June the 9th of this year is the current edition of that.
And is that 16 pages long?
It is.
Okay. And does the copy that you've sent me accurately reflect your current resume?
It does.
Okay. And this has been provided to the state. Judge, at this time, I'd ask that Defense Exhibit 13 be admitted into evidence.
No objections, Your Honor.
It'll be admitted.
May I publish it to the jury? So, Doctor, I'm working out in my head how to go through this. Where did you do your, tell me about your educational background.
Sure. So, born in Dallas, grew up in Houston, graduated from high school there, attended college at Abilene Christian College, now Abilene Christian University, in Abilene, Texas. Graduated with high honors. Then went into a doctoral training program in clinical psychology at Oklahoma State University. Oklahoma State University, that program is accredited by the American Psychological Association, which means that it meets particularly rigorous standards in instruction and research opportunities and practicum and library resources and that kind of thing. And I received both my master's and doctorate degrees in clinical psychology from Oklahoma State. I did a 1-year clinical psychology internship at the National Naval Medical Center, the large naval hospital in suburban Washington, D.C., and I was an active duty naval officer and clinical psychology intern. That internship was also accredited by the American Psychological Association. I was then assigned as a staff psychologist at the Naval Submarine Medical Center in Groton, New London, Connecticut. At that time, the sub base in Groton, New London was the primary submarine facility on the Atlantic coast. A psychiatrist and I provided mental health services and command consultation to about 15,000 active duty and about 40,000 dependents or family members, to the extent that we could provide services to them after we treated the active duty. I was there 3.5 years. While there, I did 2 years of part-time postdoctoral study at the Yale University School of Medicine. I was decorated for my service and achievements there at the sub-base with a Navy Commendation Medal, which is a very unusual distinction for a junior officer in his first assignment. I left the Navy in 1981, took an academic position as an assistant professor of psychology back in West Texas at Hardin-Simmons University. Started a practice at the same time. After a couple of years, I resigned the practice. I resigned that academic position and was simply in practice from that time. Initially with a primary focus in clinical psychology and delivering treatment services. Over time, I began to be called on by the courts in West Texas to provide consultations and evaluations. That gradually became more and more of my practice. And in the early 90s, I began a very intensive period of study to become board certified in forensic psychology.
And what does that mean, board certified in forensic and psychology? Okay,
so board certification in psychology, like in medicine, is offered in a number of different specialty areas. And in psychology, that might be industrial psychology, family psychology, clinical psychology, neuropsychology, and also in forensic psychology. There are, I think, about 10 specialty areas that board certification may occur in. In psychology, though, it's somewhat different than in medicine. In medicine, board certification is a pretty routine credential that's achieved at the end of residency or this level, and is intended to reflect the highest sophistications of practice. So, for example, in forensic psychology, there are only about 380 board-certified forensic psychologists in the United States. The failure rate at that culminating oral exam for that board certification is 40%. So it's a very arduous credential to achieve.
And could you tell us what forensic psychology means?
So forensic psychology is the evaluation and treatment of, forensic psychology is any way that psychology as a science can be helpful to some issue that's before the court. So that may range from evaluating parenting capabilities in custody cases, or psychological injuries in civil cases, or in criminal cases, things like competency to stand trial, or mental state at time of offense, or sentencing considerations such as are being heard today.
So are you a licensed psychologist in any states?
So I'm licensed as a psychologist in Texas, as well as 13 other states. My practice is national in scope.
Okay, and have you published in the field of forensic psychology?
I have. I'm extensively published. I have authored a textbook. I have authored chapters in scholarly and scientific textbooks. I've authored over 30 papers that have appeared in peer-reviewed scientific journals. I've authored a law review article. Some of my reports appear as exemplars or kind of ideals or models of reports in different forensic arenas.
Well, let me ask you, directing your attention to today in this case, have you reviewed materials related to the state of Texas versus Ronald Burgos-Aviles?
I have.
And what were those materials?
So I've reviewed his Webb County jail records. I've reviewed his Border Patrol employment file. I've reviewed the autopsy of the victims in this case. I've reviewed the portions, several hours of the video of his interrogation by law enforcement. I've reviewed data specific to TDCJ and
well, what did I
raids
ask?
and go ahead.
What did I ask you to do for this case?
So you asked me to evaluate his likelihood of committing serious violence if sentenced to life in Texas prisons.
Now, is your testimony today based in the same science as your research?
It is.
Okay. It's based on data, is that correct?
That's correct. So my research colleague, an area of particular interest that I've had and that I've published in is in what we would formally call rates and correlates of violence in prison. And that's a fancy way of saying how often does violence in prison occur and what factors are associated or predictive of it. My colleagues and I have published most of the large-scale data on that topic. By large scale, I mean samples of 12,000, 25,000, 50,000 inmates. We have also published most of the research on the disciplinary behavior of capital offenders in prison and how often they're violent in prison. And so as I'm testifying today, I am extensively relying on the data that my colleagues and I have collected, as well as data collected by other scientists.
Now, have you prepared slides in a report to accompany your testimony here today?
So I didn't write a separate report, but my slides are essentially the report of my findings and conclusions and how I got there.
Would it help this jury to see those slides?
It really would. I'm going to be talking about, and with apologies, a lot of numbers, a lot of statistics, a lot of studies. That's just a daunting amount of information to keep up with if I'm just describing it orally. So it's very helpful to be able to see that as well as hear it.
Judge, at this time, I'd ask that Mr.
Oh, we do
Cunningham,
love visual learning.
Dr. Cunningham,
Let's see the
be allowed
presentation.
to publish his slides as a demonstrative.
Okay, approach me.
Danny Dawn says, I'm a visual learner. I learn anything. Me too. I'm a visual learner. I want to see. We do like presentation time. What do they have for us? Okay, let me just take this text off for a second so we can see what's going on here. Damn. The camera view. Yeah, it was a little blurry. Now it feels like I'm sitting here in court because I've zoomed in quite a bit for the Zoom. Ooh, time to object from the prosecution. Eduardo's off to the side here. Here he is. Well, thank you all for being here with me. It's nice to be with all of you as we observe what happens in this trial. I'm thinking by the end of the week, well, this could be deliberation time. What's today? Today's Wednesday. Yeah, today's Wednesday. So maybe by Friday, will there be a verdict again from the jury? And what will they recommend? Buttercup says, I'm a visual learner too. I can memorize it. The Captain's Bar says, I really don't think this type of testimony will convince the jury. Sometimes it feels like the defense's witnesses overwhelm people. You know, I feel like the prosecution, they're very focused in everything they share. There's a reason for it, and it just feels like bullet points that are very impactful for us, okay, and probably the jury. And then I just sometimes feel like the witnesses that the defense has had, it's just so long-winded and there's so much information that it just, you clock out mentally, you know. So if any of us feel like that, I'm sure the jury feels like that. Yes. Thank you, Jessica. You're like, we love you, G. You're freaking awesome. Thank you so much. Gerda says, will it also be information selected by the defense that the doctor received or from the state too? I don't know. I think from the defense. Thank you to all the Border Patrol agents who have emailed me. I really appreciate it. I'm hearing from them, and I promise to protect my sources. And it's really nice to know that there's lots of Grizzlies in Laredo, Texas. Yes. Some have been watching since before this trial, so that's nice as well. ACE said, I just think life without parole is too kind. He'll be able to adapt and have a new normal. It'll be much more difficult to adapt on death row. Probably.
Ladies and gentlemen of the jury, because this conversation may get a little bit
Heated.
louder, where I can't keep it from your hearing, because it may be lengthier, I'm going to ask you to just go back in for a little bit, and then we'll take right back out while we have this discussion in a more
1 hour later.
normal environment.
In a more normal environment. Ooh, things are going to get heated now. Okay, so the prosecution's clearly not happy with this, right? And they're like, nope, none of this. Too much information. Irrelevant. I don't think this doctor ever met Burgos. That's probably one of the problems as well. Yes, Hilaria says, all right, Border Patrol Agent Grizzlies, yes. Those are the type of things that keep me going. You guys keep me going, of course. It just means sometimes on bad days, you know. Then when I get emails from like a district attorney or a Border Patrol agent or a detective or whoever over the years, I've been here for 2 years now. It feels like many. Over the years. Those emails are always very encouraging. Paige Willow says, yes, it's just data. I just feel like at some point, it's just too much. You need to make it impactful for the jury. Otherwise, they're going to be tired. They're going to clock out. They're not even going to listen and be like, oh, my word. You know? Yeah, Mom of 4, Rose says, just terrible, so bad for the jurors. Carol Clark says, justice for Grizelda and Dominic. Ooh, I like it when the judge is like on his chair. Then you know things are about to get serious. when the rocking begins. We can't hear anything, cameraman. Are we supposed to? Are we supposed to? There you go. Thank
the jury
you.
about these issues and whether he has, you're making it sound like if the Dr. Cunningham is going to give the jury an opinion with regard to the ultimate issue of fact.
He is,
Is he?
yes.
He's going to offer an analysis of the probability
The probability of what?
of acts of future violence
Yes,
Okay.
on
That's
who?
it?
Tell us, on who?
By your client?
essentially, yes, of Mr. Burgos-Aviles, yes.
And
Based,
nothing to do with the finding that they make,
Burgos is
which is what you were
Sulking
arguing just a
again.
minute ago.
well, but they're basing it on statistics
Yes.
that were results of capital murder convictions, some which were not even murder convictions, capital murders. It was other crimes, not just capital
Please, Judge.
murders.
Violent crime.
Just violent crimes.
In other
Or
words, what are the,
capital.
what are the,
Capital. 'Cause other states have,
a capital felony?
yes, Your
Which is
Honor.
not
Okay.
a capital murder.
And so it, again, that would be irrelevant to include those individuals. Federal law includes other things other than murder, and he includes
he's got this face
statistics
on.
from federal inmates. Additionally, Judge,
But what we're talking about here is just,
got his
what are the
sulky face on
probabilities that
today.
somebody, that there's gonna be some reciprocity, on the part of, or not reciprocity, some, recidivism on the part of, thank you, Johnny, on the part of the defendant, after committing such act, basically.
yes, Your Honor, but I suspect that the reason Dr. Cunningham does not say the proper wording on on several of his slides where he says why Ronald Burgos-Aviles is likely to adjust to prison without serious violence. That is not the standard that we have.
One second, because, Mike, did you turn on your,
Yes, Amber, we heard the statistics and the facts and everything from Officer Fitzpatrick from the
Yeah,
Texas
okay.
Department of Criminal Justice, and they're going to put him, if he goes to life without parole,
sorry about that,
straight to G3.
that was me.
If he's
Because then I
then
can't, Maricela, I can't.
naughty, more dangerous,
Miss Jackman,
G4 or
sorry.
G5.
Sorry,
They have a whole system, so I don't know what this will prove, you know what I mean? What will it prove?
what happened? Give me 1 second. I don't even see you on.
Basically, what they're trying, the defense is trying to do is prove that he will not, what? That he will not commit another violent
Oh, there
crime?
you are.
I agree, I disagree.
All right.
But they're trying to say he won't
And then
commit
I'll
another
go-
violent
okay,
crime.
Go ahead. Go ahead.
Therefore, life without parole
So
is
the
better for him.
Texas standard, as the court well knows, is whether there is a probability that the defendant would commit criminal acts of violence that would constitute a continued threat to society. And he added,
So.
Serious violence.
Whether there's a possibility that he will commit continuing acts of violence. That's the word on issue number 1,
yes, and in his slides.
special issue 1.
Yes, Your Honor. And in his slides, he has added, and it's probably because there are different standards in these other jurisdictions, he has added without serious violence because he uses statistics from other jurisdictions.
Without serious, but isn't that what's the difference between saying without serious violence and
Yeah, that's true, Maggie
serious
Beth.
acts of violence?
Well, because that special issue number 1 says commit criminal acts of violence. He's adding.
That constitute a threat to society. So, Judge, so far, everything the district attorney has said goes to weight. It doesn't go to admissibility or a demonstrative ability. Everything they can cross-examine him
Right.
about.
Look, he's
and
shaking
then
his head
the
like,
the
no.
fact finder will make that determination.
So serious acts of violence and acts of violence, you think are very different?
Well, yes, especially because he's using statistics that are not from this jurisdiction, Your Honor. He's using, and they're also old.
I mean, humans are humans, right? In other words,
Right.
are you
But-
going recidivism?
But the
Here I go again.
standard
Yeah,
is-
did I say?
Yes, Your Honor.
Recidivism is, what is the act of recidivism a human being after committing such act in Texas or in Oklahoma or in.
Because
or-
the standard
give me a
is
second.
different.
Let me finish my
Oh,
thought, ma'am,
yes.
please. And on top of that, the court reporter can only take up your conversation or mine, so it's one at a time. She's really good, but she can only take one person at a time speaking. Okay. So recidivism, why is it that a recidivism in one state or another will be different? What I'm saying. So you're saying because the data may have been collected differently? In
Yes.
other words, he may have not. Why don't we ask him that question? He may have not. He may have added an act of. He may have added.
Thank you,
He may
Debbie.
not have added an act of violence in one state, like in Florida, which would have been added, which would have been considered within the realms of violence in Texas.
Yes, Your Honor, and because serious may be in this
Well, wait,
different,
is it defined there?
no.
Why don't we ask him how he
Eh,
defined it?
Well,
Because he's the one that put it together.
and see, he also defines probability, and that is a term that even the court will not be defining in the jury
What
charge.
does the issue number one say? Possibility or probability?
Probability.
So isn't that what he should be using?
But then he defines probability as more likely than not and disproportionately likely as compared to other defendants.
But isn't that what probability means?
No, Your Honor.
I'm sorry, Mr. Elizondo. Right now, I want one lawyer speaking.
Yes, Your Honor.
Okay, and I know that you know that Ms. Jackham is more than capable of addressing the court.
Yes, Your Honor.
All right. So, isn't that what probability means? In other words, when you say when we define to the jury probability in a charge, we define it as what?
We don't give it a definition.
Well, not because it doesn't require to be defined here,
Right.
but when we do define it in many charges, isn't it more likely than not? Isn't it?
Yes, which we have no.
In fact, the grand jury will, when the grand jury indicts somebody, it is based on probable cause.
Yes, Your Honor, this is why we have no objection as to that part of the definition of probability. We do have an objection to his second part, which says disproportionately likely as compared to other defendants.
Disproportionately.
Likely as compared to other defendants.
So what was the first part say again?
More likely than not.
But read it entirely. What does it say? Let me see
Probability-
the slide. Let me see the slide. I haven't seen it. It's okay. I won't look at your notes. I'll put my finger on it. Probability more likely than not, proportionally likely as compared to. Okay, so he defines it differently. basically.
Yes, sir.
79%
So therefore,
are saying you think
they
the
may
judge
have
will allow
less
it.
people in the. I'm sorry, you're going to lose your pen. He may have less people in the Florida stats and in the Missouri stats than in the than would be normally in the Texas stats.
Yes, Your Honor, and much like the,
And why is that not a matter of weight as opposed to admissibility?
well,
In other words, you can't cross-examine them ad nauseum with regard to that issue.
then we would like the underlying
Allegedly, this
information
is
that
his
they
mom,
use for the statistics that he's using
Burgos's.
for these stats. 'cause
And behind
it's not-
here, his
it's not
grandma.
provided for us. We did not get the underlying basis for the stats. We do not know how they defined acts or assault, the serious, what was it?
Violence.
Serious violence. It could have included only murders and aggravated assault versus just assault.
This is what 705B is about, and you all decided not to do that. You can do it now.
Judge, I will say.
You can do 705B now. 705B says that you can voir dire him on his data and his, what was it? His data and his, sorry, just had it open a minute ago. Where is it? Here it is. Ah, it's tabbed, great. Facts and data underlying his opinion. So you can voir dire him, and I even asked you before we're gonna get started, do you wanna do a 705B hearing on him? And you all said, no, we already know what he's gonna say.
Well, we.
So that's why we didn't have a 705B hearing. You could have. We can have it now. Because that's the only time, not the only time, but that's when you can ask about his, you can ask about it during cross too. But you can, but you can ask about it prior to him testifying before the jury about the facts and data underlying his opinion.
Well, we were not sure, Judge, how he was going to be presenting. If he was going to present the whole thing and submit the entire document as an exhibit for the jury, or because it is 80 some pages long, and so I don't have objections
Normally,
to the majority of it.
Yeah, okay, and I get that, but you know, with regard to admissibility, I'm sorry. I'm going to go to 705D now. The underlying facts and data can always be disclosed to the jury when everything has been otherwise admissible. And of course, an expert can rely on third-party data, which normally would be hearsay for any other witness that would be testifying. So, and on certain occasions, we can even admit an expert report. I try not to do that because there's so much in there that is subject to the interpretation of an expert, and to give it to the jury that way, I've rarely done that. So, and I'm not giving you anticipatory ruling on that, but I'm just telling you ahead of time what I normally do. It is subject to, 403 and all sorts of other objections. But at the end of 403 situation, normally I see it in the flip side of things, where the prosecution is trying to get the reports in, and the defense makes the arguments. But this time it's the other way around. In any event, I get you. I get what you're saying. Again, I think you should take a crack at these type of, especially on this issue, because it
Yes,
seems
sir.
to be at the crux of your concern. And your data and if you want to do a 705B hearing specifically on this issue,
Yes,
then I'll let you do that.
thank you.
Judge, I'm sorry. I feel like, and I have great respect for the district attorney's office, but this was a bit of a stunt, because
A stunt?
we literally asked the district attorney whether or not they wanted this hearing, and they said, no, we have the report. And then when the jury came in, they suddenly said, may we approach, and then very loud,
Oh dear.
within hearing of the jury, started to give their arguments against it. So,
Well, I know that was your interpretation of it, but it was not very loud at all. In any event,
Look at the judge.
you got that in, and I'll put my take on what that was. In any event, the jury's been out now for a while, and
And
And for the record as well,
Welcome back
Judge,
in.
I believe Mr. Boggs sent us this, how many days ago?
a few days ago,
So-
with a similar type of notice that I received. I think we had to, as soon as it was finished, we sent it. It was a few days ago. I can't remember.
yeah,
My days
this
are mixed up.
is the world we live in criminal law when it comes to experts, unfortunately, and especially because the defense doesn't carry the burdens of any sort, and therefore when we do require them to give you notice of who their expert or designate their experts. I think I gave a date for that. Normally it's 20 days. I may have given a different date in this type of situation, but.
Jeeps, that's it.
But,
80 pages. OMG.
In any event, that's
We're gonna
the
be here all
world
night, you
of
guys.
criminal law when it comes to experts on the defense side, and here we go.
And Your Honor, for the record, we received this at 6 a.m. Yesterday, and the CV as well. So there was absolutely no purpose.
There was a designation of him as a witness some time ago, was it not?
There was a designation.
But that was it.
But nothing with regard to general opinions,
No,
or
Your
description of
Honor.
the general opinion.
No.
And of course, this is a criminal case, and they
Right.
don't have to give you all sorts of information. I know that there's exceptions when it comes to experts, because they have an ability to retain a counter expert, and that's why we have a designation date, and that's why designation date should include a general description of the expert's opinions and thoughts. And unfortunately, no one brought it to my attention that the designation did not include general opinions and thoughts, so I did not rule on anything. But if it would have been brought to my attention, perhaps we wouldn't be in this situation. In any event, we are where we are. 705B is going to be restricted in this situation, hearing to just questions on voir dire. He is not subject to a Daubert Kelly Robinson motion, so questions for voir dire purposes on 75B hearing dealing only with the expert, question to the expert about the facts and data underlying his opinion. Thank you. You may proceed. Oh, let me
no,
get
it's
you.
hearing time. Right?
You're
7:05
actually
B
on
hearing
there
time.
already. So let me just spotlight you. All right, there you go. Can you see her there, Dr. Cunningham?
I can, Your Honor, thank you.
And can I get that speaker over there to closer to Ms. Jackman?
Okay.
Can you do me the favor?
When he does the sarcastic
Or
smile,
should
the
we do
judge,
one?
right?
Thank you, sir.
Sorry, there's only one speaker.
Say speakers hit microphone, right? Thank you.
Here we go. Another hearing, second one of the day.
Quickly, please, let's go.
Yeah, let's go.
Good afternoon, Dr. Cunningham.
Good afternoon.
And can you turn your microphone on this side, the long one, the, what do we call it, mono? I said unit, I think it's mono, and anyway.
Can you hear me?
I can, thank you.
Thank you. My name is Marisela Jackman, and I'm the prosecutor for the state of Texas. And I wanted to begin by some of the slides that you included and ask you a couple of things regarding because much of your report is based on statistics, correct?
That's correct, group statistical data.
And
It's
so,
been individualized to Mr. Burgos-Aviles.
now, these statistics are also, and I believe that you're licensed in various states, and so you have information and studies and research from various states, correct?
I do. The research demonstrates that there is significant generalization from one correctional department to another because they share accreditation and procedures and the sorts of a mix of inmates and a number of factors for why data generalizes from one correctional department to another, just like health-related data generalizes from one state to another.
Now, you are familiar that the state of Texas has a very specific standard to determine whether or not a capital murderer, a convicted capital murderer, receives the death penalty or receives life without the possibility of parole, correct?
So there are shared issues from state to state. Texas is unique in having a special issue number one, of whether there's a probability the defendant would commit criminal acts of violence that would constitute a continuing threat to society. That's unique to Texas's capital sentencing scheme. In other jurisdictions, future violence in prison may be a statutory or non-statutory aggravating factor that the jury considers, but only in Texas is it a special issue.
Yes, and so that leads me to the question where and I'm going to refer to your slide, and it is on page I think the first page you mentioned, and this
Could
is
you
on page 13.
could you give the page number so that he could put it up on screen?
I'm sorry?
Give him the page number so that he can put
It's
it up
page
on.
13.
Page 13, Dr.
Yes.
Cunningham.
Who's going to put it up on? Oh.
He is, I'm sorry.
Okay.
Your Honor, do you desire that I put it up on the screen?
Oh, yes, sorry for the
Oh,
confusion.
I'm sorry. Am I been equipped to share
Yes, you have.
like I have? Okay, so let me go to that slide.
Oh, my word, okay. Oh, sorry, you're saying who's this guy? Let me put it back up. Dr. Mark Cunningham, clinical psychologist, one of the defense's witnesses. And
My
right now,
sister
the hearing is a
references.
705B hearing. Waiting to see if his presentation will be allowed when the jury's back in the room. So the jury's not in the room right now.
I'm getting a message that it may not be able to record the contents of the screen, but I'm not sure that we're looking for it to record or simply display.
Just display.
Let me see if we can get it up.
We're not recording, well, I'm recording on our end. I think, well, I don't know, Cindy, I don't think you're recording, right? No. All right, there's,
And let me go ahead and make it a larger view.
there you go.
Thank you, Dr. Cunningham. So where it says serious violence, does that mirror the standard that's used in the state?
So just so I know that what you're presenting to me here is that we want to know that we want to know after the fact, after the decision has already been made, and this is the decision that in other words, if a jury makes a decision to place this man on to answer the questions that will result in him being placed sentenced to life without the possibility of parole. After that, what is the probability of what would happen in terms of his conduct? Not before, but after that's done. In other words, once he's already in prison. Not,
That's correct,
not
Your Honor.
before.
Right.
He's not before the decision of the jury has been made, but after the decision of the jury has been made. I don't think that from what I heard, the witness is not going to be given an opinion to the jury with regard to what they should do with this man. Are you?
That's correct, Your Honor.
Okay.
That's correct.
He's going to be given an opinion with if a decision is made to place him, to answer the questions as such that he's going to be placed, that he will end up going into prison for life without the possibility of parole. This is what his conduct is likely to be. I think that's the way I get it. Go ahead.
And so my question to you is there a reason, or is it significant that you added serious to the word violence when it is not included in the standard for the state of Texas? Is it?
Oh, yes, ma'am. Yes, ma'am, there is.
What is that?
Well, the standard for the state of Texas describes a probability of acts of a certain severity, not simply criminal acts of violence, but that would constitute a continuing threat to society. As a psychologist who is undertaking a violence risk assessment for prison, if you want to know the likelihood of something happening, you need to specify the severity of it. And so I am operationally defining for my purposes of evaluation. I'm not telling the jury they have to define it this way, but for purposes of my evaluation, I have defined continuing threat to society is acts of serious violence. That's based on a concept in risk assessment called proportionality, that the intervention that's brought to bear have some proportionality to the harm it's intended to prevent. In other words, would you sentence someone to death in order to prevent a mutual fistfight at some point in time in the future? As a psychologist undertaking a risk assessment, I'm identifying a standard of serious violence, but as I'm describing the statistical data throughout, I'm actually reporting disciplinary misconduct, potential violence, minor assault, serious assaults, assaults with serious injury. I'm providing data on a spectrum of how often violence happens of different severities, so that the jury has an illuminated way of making their own determination of what they find to be proportional and what that likelihood is.
And
So it's not simply restricted. The data I'm reporting is not restricted to serious violence. I'm describing, for purposes of my opinion, I think that he's likely to adjust to prison without serious violence. And by serious violence, I mean an assault that resulted in more than first aid treatment, or that had the potential of injury beyond requiring first aid treatment.
it's not in your studies where you indicate that some of those assaults are considered between a consenting adults and therefore would not be included in the statistics?
Well, no, ma'am. This is all based, the statistical data is based on prison disciplinary files. And so if they record a disciplinary incident, then we count that. If they identify it as potential violence, that's how we log it. If they identify it as a minor assault, that's what we describe. We've tried in our research to get additional data about these beyond just minor assault or more serious assault to include the degree of injury that the person who was assaulted sustained, so that it is more transparent and illuminates more of the severity of those assaults. So this is intended to be, both in the underlying publications and in the testimony, to be transparent across a spectrum of seriousness of assaults.
But do you agree with me that the data, if you want to give a comparison for the defendant through some of the data that you've collected, that it should be based on data that is relevant and present in this particular case for Texas?
I believe that all the data that I'm describing is relevant to Texas. And that's because that again is because there is significant generalization from one correctional jurisdiction to another. And so for that reason, the data that's drawn from samples in Missouri or Florida or Oregon, those prison populations correspond significantly to the mix of inmates who are in Texas. And the way Texas inmates are classified and the way that they're housed and the disciplinary procedures that are brought to bear, there is tremendous similarity from state to state in those state Department of Corrections. They belong to the same correctional associations. They're accredited by the same organizations. They have broadly the same mix of offenders that they are housing. They bring the same disciplinary responses to bear.
Now, for example, in this slide on number 13, where it says special custody in TDCJ, you are aware that there is no special custody classification in TDCJ for law enforcement?
There are many different specialty classifications within TDCJ. There are units for intellectually disabled offenders. There are units for medically compromised offenders. There's administrative segregation. There is safekeeping. There are many different special custodies that are available within TDCJ. As I address this, I'm not limiting it to the safekeeping unit, but rather describing that as TDCJ is classifying and assigning inmates to units, they do that with an eye in trying to limit the victimization of those defendants. And so sex offenders, for example, tend to be housed on units that are heavy with sex offenders. My expectation is that law enforcement are not simply dropped into the mix of the prison population to say good luck, but rather they also are going to be assigned to units that reduce the likelihood of them being victimized. That may not be safekeeping. It may be units that have other law enforcement on them, or sex offenders, or other populations that create less risk of victimization. And that's what I mean by special custody. That notice will be taken of who Mr. Aviles is and his occupation as he comes into that custody.
Now, are you aware that we had a TDC administrator testify that there would not be he would be classified as a G3 general population classification, and there would not be.
Oh, yes, ma'am. I understand that he would be classified to G3, but just because somebody's classified to G3 doesn't mean that then they are simply anonymously dropped into any G3 unit in TDCJ. Where they're placed is going to be informed by how violence can be limited and how their victimization can be prevented.
Now, Dr. Cunningham, when you were discussing the statistics that you'd like to use from the different jurisdictions, do any of these have capital punishments that were not capital murder?
No. No, there is no death penalty jeopardy in the United States for a crime except murder until very recently. Florida has enacted a statute that child sexual offenders may be subject to the death penalty. I don't know that somebody has yet been convicted under that.
What about
all capital offenders nationwide have been convicted of a murder.
including federal?
Yes. That's by Supreme Court case law, that the death penalty is restricted to persons who have committed a murder. Capital robbery, capital rape were done away with decades ago.
Until recently, you said in Florida.
Recently, Florida has passed legislation that child sex offenders could be subject to the death penalty. That hasn't had time for anybody to be convicted and sentenced under that, nor has that been tested in the courts. But otherwise, nationwide, death penalty jeopardy is restricted to persons who have been convicted of murder.
Now, I'm going to direct your attention now to, it is there are some slides where you're referring to, I believe, some of the research you've conducted, and the one that I found right now was on page 82, slide 82. And
Let me go there.
And it was just, I randomly picked it because I noticed this. It says serious rule violations in high security prison, all inmates against match murderers, and you say base rate, and then you say defendant. Now, are you referring to Mr. Burgos, this included Mr. Burgos in these stats?
Oh, no, ma'am. If you back up a slide for this comparison to slide 81, and this is in a section of my testimony where we're comparing offenders with characteristics that match Mr. Aviles in that prison population, and then comparing them with other inmates. So in this case, this is a sample of 3,700 male inmates in a high security, maximum security prison, the kind of prisons where G3 inmates are assigned. And we're comparing those high security inmates to convicted murderers that match certain predictive characteristics of Mr. Aviles, and that includes that they're convicted of murder, they're serving life without parole, they're age 33 or older at intake, and they do not have a prior conviction. And so among that matched group, as we compare that matched group sharing those characteristics with Mr. Aviles, and we compare them to the 3,800 inmates that they're side by side with in the same prisons, then the base rate, that's the rate of violence among these 3,800 inmates as a whole. And then the purple, the defendant, that means the inmate sharing those risk characteristics with Mr. Aviles. And so you get a comparison of how do those offenders, those who had those matched characteristics with Mr. Aviles, what's their prison violence as compared to the other inmates they're side by side with in terms of potential violence, minor assaults, that would be things like fist fights, or major assaults.
So, wherever you refer to the defendant, you're not really referring to the defendant in this case. It should probably say match comparison group. In other words, defendant is when you say defendant, you mean match comparison group, correct?
Yes, ma'am, as described on the slide just before it. Obviously, Mr. Aviles could not have been in that prison system
Right.
to be, over that period of time, to be compared with other high-security inmates. And so defendant is simply a shorthand for defendants matching the characteristics.
Is there any other data source you want to review?
Yes. I'm looking at, the data that you had on, it's a Missouri, I think it was, you said Missouri?
I'm sorry, what slide are you on?
It's on slide 65, and the slide's entitled Relationship of LWOP Sentence to Prison Adjustment.
Yes.
If I could get the data that was used on that?
Well, yes, ma'am, that's described in the paper that you see cited at the base of that slide.
Yes, but it doesn't specify how many, what the sample size was? I'm asking for the underlying
yeah,
data.
I would simply need to turn to the, well, actually, yeah, I would simply need to turn to the article. The first edition of that study is described on slide 64. And that, so we did we examined first 11 years of records from 1991 to 2002. Then in 2014-15, we did a follow-up of that data and extended it. But I would simply need to turn to the article to identify what the size of the N was, and can certainly do that.
Yes, that would be greatly appreciated so that we can get the sample size that we used in comparison, I guess, to the rest of the group. I just would like to get that sample size. Additionally,
Do you want me to retrieve that now?
Yes, and so, just so that I could be provided that before you testify or I get to ask you any questions. Additionally, there is on page 96, I'm not sure where this risk measurement or these predictor variables are coming from.
Yes, ma'am. If you go to the slide just before it.
Okay.
So the descriptor is always just before you see the bar graph. And then the scholarly source of that will be at the base of the slide. In any of these articles that you would like copies of, I'm happy to provide. So in this case, this is data from TDCJ, and the sample size was 110 capital offenders who were initially sentenced to death under this special issue, and then subsequently got relief from their death sentences and are followed in the general prison population. So the follow-up period of these 110 capital offenders sentenced under the special issue was 1989 to 2008. They averaged 9.9 years on death row and then averaged 8.4 years in the broader prison population. And we were looking at dangerous rule violations. And the predictors in this case were various personal characteristics, criminal history, and offense variables. And we did a logistic regression analysis to identify what characteristics or features were associated with a greater or lesser likelihood of violence in prison. Based on that regression analysis, we created what's called a Burgos scale, which is a simplified way of weighting risk factors, the relevant risk factors. And so if a factor increased the likelihood of violence in this actuarial model, then there is a point added. There may be features that are neutral, they don't add or subtract. There are other features that subtract. These are then simply additive. The features from this risk model that we would apply to Mr. Aviles is age greater than 31, normal or high intellectual functioning, and multiple victims.
Now, are there additional predictor variables included in this article?
No, ma'am. Well, we examined many different possibilities. These are the ones that ended up being predictive. And so these are the factors that this actuarial model is then built with.
May I have
So we
this?
consider lots of variables.
And these are discussed in this article as well?
Yes.
May I have that article as well? Or is it the same one?
Sure.
Please
Oh,
share.
no, I mean, this is a different article that is referenced before, and I'm not actually writing down right now, so if somebody is keeping track of the slide numbers
I think
that
it
you
was,
would like copies of the articles of, that I can then
So far it's-
email those in PDF.
so far it's the one on page 95 and the one on page 64.
That is correct, Judge.
So 95 and 64?
That's correct.
Thank you, sir. I will be sure to make those available.
I think you can send
And I
those,
can,
you can send
I
those
can
to
email
Mr.
those as PDF to the defense attorneys or whoever you designate.
Send those to Mr. Boggs. Mr. Boggs will immediately send those over to Ms. Jackman. Or who do you want,
Yes, Your
Mr.
Honor.
Boggs? Maybe Mr. Boggs is not the best person to send these to. How about you guys over there? Anybody? Either, do you have Mr. Shonemans or Ms. Pozell's email?
I don't think so.
Okay, they'll email you right now, and then you can get that to them. Thank you. Sorry about that. Okay, go ahead. Anything else?
No, Your Honor, did I ask him, which of the two that I asked for, page?
64 and 95, I think it was.
And then I also wanted to get the statistics for page 47, which is the Potosi Correctional Center, the statistics that they use there.
Okay.
And there was,
The whatever, yeah, the citation you make is there on page 47, Mr.
Right.
Dr. Cunningham.
and there's one other judge, if I can just give it. I believe there is, on page 55,
Yeah, we had that already.
of the manuscript, yeah.
Oh, 65, I did not. I did
55.
64. Okay, so 65 also, please.
No, 55, Your Honor.
I'm sorry.
On-
Okay.
On page 55,
55 is unpublished data at this point, so this is a manuscript that we are working on. Let me see if I can find,
Not sure you actually discussed that, but anyway, yeah.
let me see if I can find an additional description of these data.
Okay, so she's,
They're described, well, let's see, no, this is a different one. Yeah, let me see if I can identify this.
page
Thank you so
55,
much,
yes.
Vivian. That was so
and the
sweet.
particular reason I'm asking for this is because it does say manuscript in preparation. I didn't know if it had been peer reviewed for publication. And I also wanted.
Actually, you just want where the data source
Yes,
is.
but because I wanted to know if they were federal or which state.
The data source of where you got
Yes.
that.
Oh, I'm sorry, this is from the Oregon Department of Corrections, and this is data that we are in the process of analyzing. A paper has not yet been submitted with these data, but this is from the Oregon Department of Corrections.
So if you have that, I don't know what type of volumes you may have on that type of, I would imagine that if this is raw data, that it comes in some sort of voluminous type of thing. So it's not summarized. Do you already have it in a summarized fashion, perhaps citing to the Oregon Department of Corrections?
Your Honor, I can look and see. This is drawn from a pretty extensive statistical data set that I may not be able to put my hands on in a short period of time. But I can see if there has been something that we have that's been written up about this. There may be.
All right, but just make reference to it if you send that email to these folks.
I just wanted to make sure before I sent the email that this was the entirety of the underlying data that was being requested.
Could you say it a little bit louder, because I couldn't hear you?
Yes, Your Honor, I would just like to make sure before I send this email to Dr. Cunningham that it's the entire universe of data that is being requested from him for this purpose.
Or the summary of it, I
Well,
guess.
Your Honor, if
From
I,
the slides, is this the complete list of slides for which you would like the underlying data?
Your Honor, if I could, I would like every one that he cited to, if we could get the underlying data. They're his articles. He uses.
You're not going to have time to review all that. Do you know what underlying data means? it's volumes
but
and
there-
volumes and volumes of data from over the course of years
But he-
from, excuse me, from the Departments of Corrections of everywhere, and you're gonna have to cross-examine this witness. You'd rather have the summary of it as opposed to the data itself, wouldn't you?
I think that would be for us to decide, Your Honor.
Okay. Just send her
Your
the data,
Honor,
don't send her the
if I can-
summaries. Don't send her summaries, just the data.
Just the,
That way, you
there's
know.
articles.
Well, I thought you said you just wanted the data.
But I believe he has them in those articles, Judge.
Just ringing.
There's some
It's
that
gonna
do
drive
not have
us nuts.
articles.
They're
They just have the manuscript, which is
That
not
was
ready.
just why.
Sorry. So they're not ready. So therefore, this hearing is about data and stats. I'm sorry, data and, what did I say it was? Facts. So where are you getting the facts and the data, or the data, or the facts to put into the data? And so therefore, you know, that's where they're getting it from. So send them whatever you have with regard to the data and the stats and the articles that are referenced. And if the articles are where you get the data from, then that's where you get the data from. You don't necessarily need the raw data of those articles, okay? So in other words, if you're just citing to the article that already has the data summarized, that's what you do. That is your underlying source. As an expert witness, you can rely on that. And the rest of it is just about weight. So if you have, make clear, sort the articles, and if the articles cite the source of data and have the data summarized in that fashion, then great. If there is nothing that summarizes the data, then you're just gonna have to send them whatever it is that you have and how you were able to put that slide together with data from whatever it is that you have. You don't have to send the entire article of that manuscript because it's not ready, but if you have some data within that manuscript that's already ready, obviously it's ready because you used it to prepare that slide, then whatever it is from that particular
Judge, keep it Grizzly.
slide that you use, from that data that you use to put up that slide, then send that to.
Yes, Your Honor.
I think we've covered everything she requested.
Thank you.
Anything else?
No, Your Honor.
All right.
The only concern for me would be the slide that discusses or defines probability more than it would be defined, or as the state law says, what is commonly known, or the common definition of it.
Where was that at? It was not 13. What was that?
It was on page,
It's absolutely them with the noise. I think it's on the Zoom call.
7, Your Honor.
No, it
Sometimes
doesn't
it's a
say
clash
that
with
that's
audio
what
with a
Texas says,
guest
but
on
it's,
Zoom. I don't know.
you're saying, just to not have that particular,
It's annoying.
let's see, confusion.
it's on 7 and 12, Your Honor.
7 and 12?
Yes, Your Honor.
Okay, so it starts off by saying, well, it starts off with page 5 by giving you exactly the definition of special issue number 1.
Yes.
It would be
And
so
then
much more
it goes
efficient if they
to
just go ahead with it.
Conceptual framework,
And
operational.
Your Honor, this is as operationally defined by a forensic psychologist. And so this is like the idea of that somebody has to pass calculus. Okay, how are we going to operationally define passing calculus? Well, we might say that that's based on an A is 90% or more correct, B is 85 to 92, a C is 80 to 85. That's an operational. That's operationalizing it.
the only way-
particular calculus
1 second.
questions that somebody gets further operationalize it. So these are simply how I'm going about operationalizing this from the standpoint of a forensic psychologist undertaking this assessment.
Give me 1 second. Okay. With regard to, this is my ruling on that. With regard to my ruling on whether Dr. Cunningham testifies based on this N05B hearing, voir dire that we just had, I am going to allow him. I'm assuming that the state was in the same, really you weren't saying don't allow him, you were saying some of the stuff should not be allowed. I'm I'm allowing him to testify with regard to that. I find that the data and facts that he put together on data are suffice for his opinions. With regard to that slide that the state is concerned about, I think it's really close to when you define Special Issue 1, and I don't want it to make it sound like if this is what the state means by this. I don't want it to sound like that. And since it's real close to each other, I need for you to perhaps when you put that up, you just leave the more likely than not. And then he explains for him that why his operational, what did you say it was?
Operational definition.
Framework is, it doesn't mean that that's what the state is, as long as that's then I'll allow it not in fact, I'll allow it to be shown after he explains why he's saying that, but that it is not what he defines that to be. Because that is not the way the state defines it, that's not the way I'm going to define it to the jury, and I don't want any confusion with regard to that.
So, Judge, I believe the definition of probability was the subject of pretrial litigation by the defense, arguing that probability means more likely than not. If that is the state's position now, at that time, they said it's not defined in the law. All we'll say is that it's more than a possibility. So if the state is conceding that probability means more likely than not, we will take that definition.
Well, that wasn't, what was I even asking? I was talking about the second part of that.
Yes, so I just want to make sure I understand the court's ruling. So he is
I wasn't ruling on the
allowed-
first part. I was only ruling on the second part of it.
I wanted to talk, Judge, I'm sorry.
Okay. So on the second part, okay, now that he may raise the first part, I do remember some conversation about that in limine. What is the problem with that? Did you all not want that said?
We don't have an issue with the first one, Your
All right.
Honor. It was just the second one.
Okay, so you'll before you put it up, you will, in fact, you won't be able to put it up on, you'll have to put it up on the Elmo if you want that up. Maybe you can just skip it. But in any event, or just talk about it and not put it up, because then you're going to have to put something on it, and then he's going to have to explain that it's not the definition or whatever it is, that he's using it for his own purposes, and that's the way they use it. As long as that defined that it's not part of the definition, that he's not attempting to define that from the state.
The second part.
The second part, yes, sir.
Right. So
And Your Honor, if I might offer, I have already gone in and animated that slide in anticipation of your ruling, so that when the slide first comes up, it will only say one, more likely than not. That second part won't appear until there's an additional explanation.
Thank you. Very good.
May I have that also as to page 12? Because I mentioned.
Oh, it's there
Your
too?
Honor.
Yeah, you did mention 12, you're right. 12 may not be animated, but 12, let's say. Okay, 12 also has, in fact, that one has 1 and 1, not 1 and 2, but in any event.
Let's
I've
tell
not
the
corrected
cameraman.
that, Your Honor. That was
There's
the
a lot of
PowerPoint
feedback.
renumbered it on
Okay.
me, so mine now says 1 and 2.
Okay, so can you also
Yeah,
try and
not
make that
cooking.
split while I bring the
Can
jury
someone
in?
tell
I'll
the
take about
judge
5
all
minutes to
the
get that
guests?
done.
And,
I can, thank you, Your Honor.
and any ruling on the
Lola, I really
serious, on the
can't.
word serious
I really can't.
violence, as opposed to just.
No, because I think that there's going to be, there's going to be an explanation with regard to that, and it's not going to be part
All
of
just to
the definition. It's not close to
witness
slide
can
5.
show
and
his presentation
He's going to talk
or
about it in
not.
the terms of his data. And
Thank you.
And then there's a whole bunch of other stuff that defines each and every one of those type, like assaults, violence to staff members,
ours
and then,
is the
so they
speaker is
define
too
it
close to the
differently. So I think that
Cameraman.
plays a role.
Thank
And
you.
and the
Speaker
serious
is too
part
close to the mic.
will be definitely defined and talked about. All right, thank you. Let's get the jury ready to come in. If because I anticipate we're not going to take a break here for, I know that you have to take a break. So they told me about you having to take a break, so let's do that now for you.
Yes,
and then,
sir.
And we'll
Thank
do
you.
the same. Thank you. And so we'll try to get back as soon as possible, guys. So everybody get back in as soon as you can. Thank you.
Fury has joined us for the madness Look at him. Oh my word. So that is all just if the presentation's going to be allowed or not. Let's do a mic check, Fury. We need to do a mic check. There we go. Is the presentation going to be allowed? Yep. Are they taking a short break? 5 minutes. Yep. What does it really mean? Half an hour. Laurie Elsart, thank you so much. You say bravo. Look at that. So cute. Thank you so much.
You may begin, sorry.
So, Dr. Cunningham, what were you asked to do in this case?
I was asked to perform a violence risk assessment for prison of Mr. Burgos-Aviles, addressing the likelihood of serious violence should he be confined for life in TDCJ.
And Dr. Cunningham, as a forensic psychologist, is there an obligation to understand the role of a given evaluation in the legal system?
There is. That's part of what differentiates a forensic psychologist from simply a clinical psychologist, is a familiarity with the legal issues and how psychology as a science interfaces with those issues.
And in regard to your evaluations for capital sentencing, is this something that you addressed in your textbook on this subject?
It is.
And have you taught other psychologists about these concepts in continuing education presentations?
I have, both psychologists and attorneys.
So, Dr. Cunningham, as understood by a forensic psychologist and as structured in your evaluation, briefly describe the primary sentencing considerations.
So the primary sentencing considerations are four. So there are four of these. One of them is retribution or punishment. That's a concept that, or an issue that psychology as a science doesn't have much to say about. That's a social issue that's determined by judges and juries. The second factor is general deterrence. That's essentially the warning that's sent to the rest of society about not doing this. This is also an issue that psychology as a science, as a forensic psychologist, I don't have expertise to offer about. So these first two are sentencing issues, but they're not ones that forensic psychologists have special expertise about. The next two are within the area of forensic psychology. One of those is moral culpability. That's the idea of what raw materials and resources somebody brought to their decision making. And that may also be referred to as mitigation. And then the fourth issue is specific deterrence or incapacitation. What needs to be done to prevent this individual or lessen the likelihood of this individual committing criminal acts or serious criminal acts in the future? That's part of the idea with how long somebody is sentenced to prison. That's essentially an assignment of incapacitation, where they will not be in the larger society and will be incapacitated for a certain period of time depending on the offense.
And which of these four are you addressing today?
Today I'm addressing specific deterrence or incapacitation.
And as understood by a forensic psychologist, is specific deterrence or incapacitation reflected in one of the special issues in Texas capital sentencing?
It is. It is. It's reflected in Special Issue 1. And that special issue is whether there is a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society.
And Dr. Cunningham, as a scientist in the field of forensic psychology, what does it mean to operationalize a legal issue?
Operationalize means that you turn it into something that you can evaluate and measure. So for example, let's say the issue is you have to pass American history before you can graduate from high school. All right, somehow we're going to need to operationally define what does it mean to pass. So at what percentage correct is that you've passed? And also, what's the underlying information that you need to know? What are the test items that we're going to ask that demonstrate that you have the requisite knowledge of American history to get a high school diploma? So that's a way of operationalizing it. In forensic psychology, this is things like in an evaluation of competency to stand trial, what specific inquiries do you ask that illuminate somebody's understanding of a legal proceeding or their ability to relate to their attorney? Or if this was an insanity case, how would we go about operationalizing whether somebody knew his conduct was wrong, and what inquiries and what history would illuminate that? So operationalizing means that you take a general idea and you make it something that can be scientifically measured.
And as a forensic psychologist, and for the purposes of this evaluation, how did you operationalize Special Issue 1?
Well, I divided that into 3 elements. The first element is probability, which is more than a possibility. And the importance there is that a capital sentencing proceedings, as understood by a forensic psychologist, exist as a way to narrow and particularize the application of the death penalty, so that you have a universe of people that have committed death-eligible crimes and then a smaller proportion of them that are actually sentenced to death. Now, if the issue is any possibility, then the answer is always yes. There is always some possibility that every capital defendant would commit violence or serious violence in the future. And so if the issue is defined as any possibility, then it serves no purpose in narrowing and particularizing the application of the death penalty. So probability has to mean something more than that.
And so, as viewed by a forensic psychologist, how is a probability operationalized?
Well, probability is primarily operationalized by more likely than not that there is at least a 51% likelihood of a given act or hazard occurring. That's the primary way that we think about probability. There's also, as psychologists approach it, a secondary way of thinking about probability.
Now, Dr. Cunningham, what is that second area or way that a psychologist thinks about probability?
So the second way may be that this proportion, this individual is disproportionately likely to commit violence as compared to other defendants. So that's an alternative way that a psychologist may view probability or risk.
And as a psychologist, did you operationalize acts?
I did. So that's the second part of this. It says whether there's a probability of criminal acts of violence. In other words, acts as a psychologist, I'm operationalizing as behavior. Now that's different than if we were to operationalize this by a characteristic or proclivity. So, for example, dangerousness is a proclivity or is a characteristic that is extraordinarily difficult, if not impossible, to measure. But that's not what the Act calls for. The special issue doesn't call for an assessment of dangerousness. It calls for an assessment of probability of behavior, of criminal acts of violence.
So could you demonstrate to us how, whether and the differences between dangerousness and acts?
Certainly. As understood by forensic psychologists, if we're talking about future dangerousness, that's a prediction. The person either is or they're not. As opposed to a violence risk assessment where we're looking at varying probabilities, not just an either or. Now, under future dangerousness, if the question is a capital defendant at the point of his conviction, is he dangerous? Well, the answer to that question is always yes. As compared to your typical, citizen on the street, of course this capital defendant is dangerous. That's why at the very least he's going to be sentenced to life in prison as a permanent incapacitation from the rest of society. So if we're talking about future dangerous, now again we lose any narrowing or particularizing function of this special issue if we talk about it in terms of dangerousness. Now, on the other hand, if we're talking about assessing a likelihood of violent acts, that's going to vary by individual. Different individuals will have different likelihoods of different severities of acts. Future dangerousness relies on an intuitive methodology. What do I mean by that? That's kind of a gut check. Gee, am I disturbed by this person? Do they kind of scare me? Am I unhappy with them? It's an intuitive methodology. It's sort of like trust your common sense idea. It's an intuitive.
And
on the other hand, go ahead.
Oh, I'm sorry. I was going to ask if in your scholarly publications and seminars with psychologists, is this distinction made?
Oh, it is, yes. And so that we encourage experts as they testify to speak precisely. So future dangerousness is this convenient way of summarizing the special issue, because it's a long sentence to say whether there's a probability the defendant would commit criminal acts of violence that would constitute a continuing threat to society. So there is a seduction, a tendency to want to abbreviate that into something that's a little bit easier to say. The problem is these mean two very different things. Future dangerousness is this intuitive, unmeasurable, subject to bias characteristic that we're trying to infer, as opposed to that can't scientifically be measured with any specificity, as compared to future violent acts and the likelihood of those that can be measured and predicted.
So, Dr. Cunningham, what was the third element to be operationalized as understood by forensic psychologists?
So the third issue is of a certain severity. So the special issue says whether there's a probability of criminal acts of violence that would constitute a continuing threat to society. That invokes the notion of criminal acts of a certain severity. And this becomes important in a violence risk assessment because as we look at prison violence, the likelihood of that varies considerably by what severity of violence you're talking about. And from a psychologist standpoint, from a forensic psychologist standpoint, this also involves a concept in risk assessment called proportionality.
And could you describe what is meant by proportionality as a psychologist undertakes a violence risk assessment?
Certainly. So as a psychologist engages in a violence risk assessment, that's always with the intention of informing an intervention. So what's the degree of risk so that we can then bring treatment or confinement or supervision or isolation so that we can then bring interventions to bear to reduce that risk. So within violence risk assessment, as psychologists view this, the concept of proportionality means that the intervention bears some proportionality to the harm it's intended to prevent. And so, for example, in a capital context, would you execute a defendant to prevent a mutual fist fight someday? Does that seem proportional? And so that's why it becomes important to look at these different severities of violence and their likelihood in prison, so that an informed decision can be made about whether the intervention is proportional to the harm it's intended to prevent. Trying to prevent a mutual fist fight, or are we talking about actually we want to prevent an assault that sent somebody to the hospital?
So, Dr. Cunningham, what is your conclusion regarding Mr. Burgos-Aviles' probability of committing criminal acts of violence that would constitute a continuing threat to society?
Yes.
So if I have operationalized this, first in terms of a probability of more likely than not, I find that he is quite unlikely to commit serious violence in TDCJ confined for life.
And was there a second way that you viewed probability as a psychologist?
There was, and that is the question of whether he is disproportionately likely to commit serious violence as compared to other inmates. And I find that he is less likely to commit serious violence in prison than other inmates in general and other capital offenders, both.
And could you tell us about your individualized appraisal of what kind of adjustment Mr. Burgos-Aviles will have to a life term in the Texas Department of Criminal Justice?
I can. I have identified a number of characteristics about him from the research and from the corrections data and our research group's analysis of these that point to his having a very low likelihood of serious violence in prison. And those features are that he is age 34 at the outset of a life sentence, that he's had one minor disciplinary infraction in 5 years of custody in the Webb County Jail, that he has a high school education and some college, that he has a long-standing employment history, both in the military and also the Border Patrol, that he has continued contact with community members who write or call or visit him, that he's been convicted of a capital murder, which seems counterintuitive, but is a factor associated with low likelihood of violence in prison, that he would be serving a life sentence. Then there are a number of actuarial comparisons of examining inmates who match predictive characteristics with him and comparing them to the other inmates they're side by side with. And those actuarial comparisons also demonstrate both a low likelihood, less than probability, and also a disproportionately lower likelihood than these other inmates. And then finally, that because he is former law enforcement, that his placement in TDCJ will be on units that offer some protection against being victimized. And those sorts of units also have lower rates of violence in prison.
So, Dr. Cunningham, could you discuss what the slide says, special custody in TDCJ? Could you discuss what that means in this context?
Sure. So there are many special custodies in TDCJ. There is a special unit for inmates with intellectual disability. There are persons who've been convicted sex offenders tend to be congregated on particular units. Law enforcement across the country in the prison systems are also assigned to units with other law enforcement or lower risk environments like sex offender environments. They're not simply dropped at random into the deep blue sea of the general prison population. Now, they may be classified as G3, that's their classification and the security level they're housed with, but that doesn't tell us about what unit they're assigned to, where you reduce the likelihood of them being victimized and targeted. And on those units, the assault rates are lower. You know, there is a very small unit in TDCJ called safekeeping. It has about 61 or 62 inmates on it who are identified as needing particular protection for their own safety. But that is by no means the totality of how assignments are made for different units in custody in recognition that some inmates are much more vulnerable than others.
So, Dr. Cunningham, could you tell us what your bottom line conclusion is in regard to Mr. Burgos-Aviles?
So my bottom line conclusion is that there is a very low likelihood of his committing serious violence confined for life in the Texas prison system.
And what features or characteristics of Mr. Burgos-Aviles about his background do you base this on?
On these features that are derived from research.
Well, before you go into detail about these factors, could you tell the jury about how the risk of violence is broken down?
Certainly. So the overarching question is, will there be violence? But actually this is made up of 4 sub-questions. First, what's the probability? This is not an either-or situation that absolutely he will or absolutely he will not. I couldn't say that about anybody in the courtroom, that there's just no likelihood at all of them ever being violent in the future. So this is not a yes or no, it's what's the probability, what's the likelihood of what form of violence? Now that's important to specify, because the more severe the violence is, the dramatically less likely it is to occur in prison. So for example, the rate of assault might be in a prison system might be 10 per 1,000 per year. But the rate of homicide of an inmate is about 5 per 100,000 per year. So as the severity of the violence increases, its likelihood dramatically decreases. And that's why as I present information about the various studies that we've done, I'll describe a range of disciplinary infractions and violence where this will become obvious that things like mutual fistfights happen much more often than somebody being stabbed up and sent to the hospital, which is extraordinarily infrequent. And then the third question is, what time period? That means when in this person's life. And that's because the likelihood of misconduct in prison and violence in prison is directly related to age. The older you are, the less likely you are to get in trouble in prison or to be violent in prison. And so critically important that we specify at what time period are we talking about, and then finally in what context. Are we talking about the open, randomly assigned prison population? Are we talking about being locked down in a supermax setting like administrative segregation, or assigned to a unit that's characterized by other vulnerable persons and are less assaultive with each other? What context are we talking about?
Is there an analogy that you could give the court and this jury about risk assessment that's common to all of our experiences?
There is. So these are the same questions that are asked by the automobile insurance industry, because they're also involved in the business of risk assessment, just a different kind of risk. So they're also asking, what's the probability of what type and severity of accident, with what age driver, in what driving locale? And we're asking corresponding questions as we undertake a violence risk assessment for prison.
And are there different risk assessment techniques?
There are, and these range from most reliable, most scientific, to least reliable, most speculative, and kind of random.
Like cars.
So what is the most scientific approach in assessing the likelihood of a future hazard, whether it's a car accident or violence?
So the most accurate and the most reliable approach is a group statistical approach, also called the actuarial model or the insurance company method. And that's where you define the group and you follow your experience or the casualty rate of that group. And on the basis of that, you identify the likelihood, what's called the base rate. How many of those people have accidents of what severity? And also what factors are associated with a greater or lesser likelihood of those hazards. So this is the idea that, when my son turned 16, my insurance rates went up $1,000 every 6 months. Well, they didn't bring my kid in, interview him, look at him. They based that on their experience with 16-year-old male unmarried drivers. And on the basis of that experience, they then set a hazard prediction, if you will, for my kid. And so I figure these kids cost them an average of $800 every 6 months, $100 for clerical, $100 profit. My rate goes up $1,000.
So could you talk about the role of statistical or group data for predicting future serious violence in prison?
So as we think about this group data, the maxim in violence risk assessment is that knowledge of the appropriate base rate is the most important single piece of information necessary to make an accurate prediction. Now, the base rate is simply how often does violence happen in a group of similarly described persons. That's what that means. Base rate data is the fundamental information in medicine and in psychology. So for example, you go to the doctor, he looks in your throat, he identifies what appears to be strep, may do a sample to confirm that. And his choice of therapeutics, that when he writes you a prescription for an antibiotic, that's based on a group of people that you didn't belong to who had a similar infection and what percentage of them responded to this particular antibiotic with what positive response and with what side effects. And a lot about the practice of medicine is simply knowledge of thousands of base rates and how those apply to the clinical treatment. So in the same way as we're trying to identify what's the likelihood of this defendant committing serious violence in prison, then we look at risk-related characteristics about him and the associated base rates of how often is misconduct or violence happening in persons that share those characteristics. That's the most scientific approach to make.
And is there a scholarly consensus regarding the role of group data in assessing future risk of violence?
There is, and it's this notion that if you can't have any other information, you want to know the base rate.
Now, let's talk about what the next most scientific approach in doing a violence risk assessment.
So the next most scientific approach is a past pattern approach or method. This is the idea that the best predictor of future behavior is past behavior. And so essentially recognizing the stability of patterns of human behavior over time, you use patterns of how this person behaved in the past to estimate how they're going to behave in similar situations in the future.
Dr. Cunningham, will you talk about the role of past behavior in predicting future behavior?
Certainly. So past behavior is a very strong risk factor for future behavior, assuming that you have three critical elements. Number one, you have to have enough behavior to form a pattern. So one act is not a pattern. You need to have enough behavior to form a pattern. The context of prediction is sufficiently similar, and you're in the same broad phase of life. So this past pattern is a very powerful risk predictor if you have these three elements.
And is there a scholarly consensus regarding the role of past behavior or prior violence and future risk of similar behavior?
There is. So let's look at this idea of enough behavior to form a pattern.
You don't know that.
Our context prediction in the same broad phase of life. So as we look at this idea of the context being sufficiently similar, what the science demonstrates is that a pattern of violence in the community, is associated with an increase of future violence in the community. Even a pattern of violence in the community is not reliably or consistently predictive of future violence in prison. So community violence predicts community violence. It does not predict prison violence. Prison violence predicts prison violence. So somebody's got a pattern of violence in prison, that predicts more violence in prison, not their community behavior.
Are there everyday examples that you can provide of context in predicting behavior?
Sure. So the way that my son would drive on Friday night when he's out with his friends might have no correspondence to the way he drives on Sunday morning with me sitting next to him in the front seat. Same kid, same car, fundamentally different context. The way the class acts with their regular teacher does not seem to predict how they behave in front of the substitute teacher. Same kids, same classroom, fundamentally different context. So context is really key here as we try to make sense of what community behavior, community violence has to do with prison violence.
Dr. Cunningham, could you talk about the current state of science regarding what a pattern of violence in the community predicts?
I can, and I'll illustrate this with a study that my colleagues and I did. And this is an example of some of the very large-scale data sets that we examined in trying to understand rates and violence in prison and what factors are associated with it. So in this instance, we had over 23,000 offenders who were admitted to prison. And we had access to a computerized database of their behavior after they got to prison. And what kind of infractions and violent infractions they were engaged in prison. We also had a data set of their criminal records that reflected their past arrest and convictions. And so because we had a those dual data sets on these 23,000 inmates, we could then examine what one had to do with the other. And perhaps most startling is that if you go to the bottom bullet on this slide, having been convicted of a homicide, either that you're in prison now on a homicide or you had been convicted of a homicide in the past, was not associated with an increased risk of prison violence. Now that's a very counterintuitive. That's kind of the opposite of what you would think, as you would just sort of sit and think about, so who's going to be violent in prison? When we actually look at the data, and we'll look at other studies that confirm this, it's simply not associated with an increased risk of prison violence. Now, even the rate of violent arrest, even if somebody was getting arrested more often in the community for violent offenses, that was also not related to assaulted prison misconduct. So they were doing this repeatedly in the community, come to prison, it doesn't continue. Now, there were a couple of factors that were associated with a somewhat increased risk. If there was a prior arrest for assault and a current conviction for robbery and or assault. So if you had those two things, that was associated with an increased risk of prison violence. Now, even then, it didn't make it more likely than not. That's in relation to low base rates. And here's what I mean by that. So let's say that the incidence of assaults is 5%, and you have a pretty powerful risk factor that doubles the risk. Well, where are we now? Well, now we're at 10%. We doubled the risk. That means 90% of those guys will not be violent, and 10% of them will. So you always want to examine your risk factors in relation to what's the base rate. How often is violence happening in this group?
And Dr. Cunningham, has the U.S. Department of Justice weighed in on this issue?
They have. So even before we began to publish our large-scale data sets, the U.S. Department of Justice and agencies within DOJ had already identified this same finding based on their decades of experience with inmates being confined in state and federal prisons nationwide. And here's the primary findings that they had. Number one, past violence in the community is not strongly or consistently associated with prison violence. Number two, the current offense, prior convictions, and escape history are only weakly associated with prison misconduct. And finally, the severity of the offense is not a good predictor of prison adjustment. The severity of the offense that sent this person to prison.
So, Dr. Cunningham, these are published conclusions by the Department of Justice?
They are.
Okay, and what do these findings show us about community criminal history as a reliable basis for asserting a more likely than not probability of prison violence?
It's not a sound basis. That would be an error to make that kind of inference.
So, Dr. Cunningham, can you provide an everyday example of the application of the same broad face of life?
Well, certainly. So, if I apply for automobile insurance and I'm 50 years old, State Farm is not interested in my driving record when I was 16 to 20 years old. They're interested in the last 3 to 5 years. Because the way that a single male drives age 16 to 20 has no correspondence to the sort of driver he is out here at age 50. And so it's critically important, and for that reason the insurance rates are very different, whether the insurance company is examining the significance of tickets for a 16-year-old and whether those have any application at all, 20, 30, 40 years later. Because driving behavior like violence has a significant association with age.
And Dr. Cunningham, what is the next risk assessment approach in the hierarchy of more to less scientific?
So the next approach is what we would call intensive clinical evaluation. And that's what you might expect a psychologist to do, which is to go in, interview Mr. Burgos-Aviles, take a history from him, observe him, on the basis of that, identify personality characteristics about him, and from those personality characteristics, infer his long-term violence likelihood in prison. That's what you would think a psychologist would do. The problem is that approach is notoriously unreliable. It simply doesn't work. Now, in this case, I have not gone in and interviewed Mr. Burgos-Aviles. I've watched him on the interrogation video. I've looked at his jail records and his employment records, but I have not interviewed him or tested him looking for those characteristics.
So
and part of the reason I haven't is because my sitting down with him directly would not be looking for personality characteristics. That has nothing to do with it. I would be taking a history from him about how he's been confined in jail and problems that he's had in jail, if any, disciplinary misconducts and those kinds of things. I would only be gathering data from him about factors that are scientifically related to likelihood of violence in prison, and I can get those from other records and other information. So although it seems like that's what would be the way to do it, it actually doesn't work.
So are you saying that intensive clinical evaluation increases the likelihood of predictive error?
It does. If that's what you're relying on, if you're looking for personality characteristics to make this differential. And some of this is related to base rates. So let's say that I interview somebody and I identify that they were violent and so apparently have a capacity for violence. Only over 60% of the inmates in TDCJ are currently serving a sentence for violent offenses. Most of these guys have violent histories. Well, anytime you have a feature that's present in a large proportion of the group, it's not going to predict the infrequent act. Let's say that I identify that he is impulsive in some fashion in the quality of the judgment that he brings to bear. Well, while I might think that was predictive, almost everybody in prison is impulsive. That's how they went to prison. is doing things that were ill-conceived and bad judgment. And so again, a characteristic that's universally present doesn't then predict the infrequent act. It's just not going to work.
So, Dr. Cunningham, I'd like to talk again about the importance of context in violence risk assessment. What are one of the fundamental flaws in this model?
So, what the intensive clinical evaluation focuses on is who is this individual? Who is this defendant, and what are his characteristics? As if violence is just a function of that individual. And so if I understand him, then I can identify his likelihood of violence in all contexts. Now that is a mistaken notion. And this has been well established in the risk assessment scholarship and field for over 40 years. Back in 1987, Hall conceptualized the likelihood of violence as involving the interaction of an individual with specific environmental factors at a certain time, place, and setting. And it's the interaction of those things that produce violence. The conclusion is that individual persons are never dangerous in toto. That it isn't ever just about this person, but this person in particular interactions in particular settings.
I object.
So, Dr. Cunningham, have you prepared a model that demonstrates how factors resulted in someone being violent in the community and in their capital offense, that it's not the same in prison?
I have.
Alani is taking notes.
So as violence is understood by risk assessment scholars, violence is the result of a person who is in a particular interaction in a given context. And it's out of that whole matrix that you get violence. So then, this is the open community, let's say. When you go to prison, now there's an inmate who is interacting with other inmates. These are guys who are in prison for a reason.
Okay, sorry.
And also, these are guys you're going to have to deal with if you're a capital offender for the rest of your life. And you're going to have to deal with them and their friends and their cousins who you may not even know. And you're also dealing with vigilant staff who are well trained and who you are also going to have to deal with from now on. And God forbid you're getting escorted down the stairs with your hands handcuffed behind your back and you trip. So this is a very different interaction context, and that is also highly restrictive with eyes-on monitoring, video monitoring, concentric layers of security, cell searches, a very restrictive context. And the effect of that is to form a barrier to block the occurrence of most serious violence.
So, Dr. Cunningham, could you explain this model related to specifically to the Texas Department of Corrections and Justice?
I can. So if we look at TDCJ, so who's in TDCJ? So we think about this notion of who are these guys? Well, 16,000 in TDCJ have been convicted of a homicide. That's almost 14% of the population. 75,000 are currently serving a sentence for a violent offense. That's over 64% of the Texas Department of Criminal Justice inmate population. Now, of the 122,000 that were in prison in Texas in 2022, 62,000 of those were G3 offenders, like Mr. Burgos-Aviles will be classified as should he get a life sentence. That's almost 54% of the population. Among those G3 offenders, about 95% of those G3 offenders are serving a sentence for a violent offense. Now, they're not all violent offenders, but almost 95% of them are. Now, these are also guys that are serving, a portion of them serving extended sentences. 28,000 are facing sentences of 20 years or more. That's 23%. and there are 3,300 that are serving a capital life sentence or a life without parole sentence. That's 2.7%. So you would think that with 75,000 violent offenders this trip that they're serving a sentence for, 64% of the population, almost 2/3, 14% homicide, 62,000 G3 offenders, 59,000 of them violent. You would think that the rates of violence in TDCJ would be off the charts if violence is a function of just the person. Well, here's what's happening in terms of the violence. These are data from fiscal year 2022, Texas Department of Criminal Justice. In that year, in spite of this mix of people that are in Texas prisons, 99% of them didn't assault anybody in terms of serious assaults. So you did have inmate on staff assaults. There were about 6 of those per 10,000 inmates. The inmate on inmate serious assaults were more frequent. There are about 10 of those per 1,000 inmates. 99% don't commit serious assaults. Now, as we move, in spite of the level of violence that these individuals had in the community, the rate of inmate on inmate homicide in Texas prisons in 2022 was 5.7 per 100,000 inmates. About 6 of those for every 100,000 inmates. Now, how does that compare to the Texas open community? Well, the Texas open community, that's men, women, children, little babies, little old ladies, the rate was 6.6 per 100,000. In other words, in spite of these 2/3 of the offenders in Texas prisons serving a sentence for a violent felony, the rate of homicide in Texas prisons is lower than in the open community. Now, if we were to demographically match the prison population to the open community population, males of a particular age and education level and that kind of thing, the rate of homicide in the open community in the United States is about 35 per 100,000. In other words, it's 7 times greater than the rate of homicide in TDCJ. So Texas prisons are not perfect in incapacitating inmates, but they are extremely effective. And this also then demonstrates how powerful context is in providing an incapacitation of offenders that showed a willingness to be violent in the open community.
So, Doctor, what's the next approach in violence risk assessment in terms of scientific reliability and validity?
So even less reliable and increasingly speculative is hypothetical inference. So that would be like, so Dr. Cunningham, I want you to assume that we have somebody who planned, however poorly, to kill a woman and a child that he was involved with, and then he lied about it and denied it, and there are these other things that he did. What do you think of somebody like that and his likelihood of being violent in prison? Now, so we've gotten a few points of light. It's like seeing animals in the stars. You take a few points of light and you draw the shape of some creature. Only you could really draw the shape of anything from those points of light. And so that approach, kind of appealing to an intuitive gut reaction, results in profound error in estimating risk.
So what is the least scientific and most error-inducing approach to violence risk assessment?
So the most error-inducing approach is anecdotal example. And so that would be like, Dr. Cunningham, we've got this inmate, this capital inmate, Gonzalo Lopez, that effected an escape from a prison transport bus and murdered some individuals out here. And so we tell the story of this escape the effect of that, the way the human mind works, is that when we're presented with a particularly lurid example, it just drives our fear and concern off the charts.
So
Now, the problem, of course, is Gonzalo Lopez has nothing to do with Mr. Burgos-Aviles, and this is an extremely low base rate behavior. It's extraordinarily infrequent that an inmate, capital inmate escapes or someone escapes from a secure perimeter facility. It happens, but it's so rare that it makes national news when it does. So this also involves raising any possibility, however remote, to then drive up the fear analysis that's brought to bear.
is there an analogy or an example you can use to illustrate raising that fear analysis?
Well, sure. So if you went down to your local airport and in the concourse they had posted these huge billboard photographs of crashed airliners from the last 50 years. In the interest of educating the flying public about what could happen when you get on an airplane. Well, of course, those photographs, those anecdotal examples would drive people's anxiety and fear through the roof. Now, the reality is that your drive to the airport is overwhelmingly and extraordinarily the most dangerous part of the trip. The casualty rate per passenger mile in a car is huge compared to passenger mile in an airliner. And so those photographs of those anecdotal examples would not serve to increase the accuracy of your judgments about flying. Instead, the way our brains work, it would scare you and perhaps you wouldn't even get on the plane and would drive instead, putting yourself at much, much greater risk as you went down the highway.
Dr. Cunningham, can we return to the factors you specified regarding Mr. Burgos-Aviles and his low likelihood of violence in prison?
Yes, sir.
What is the first factor supporting a conclusion that Mr. Burgos-Aviles is likely to adjust to prison without serious violence?
So the first factor is that he is age 34 at the outset of his life sentence. So his date of birth is April 19th, 1989. So he is 34 as he enters TDCJ.
And how is age related to misconduct and violence in prison?
So this is one of the most clearly established findings in penology or prison science. And that is that the age of the inmate is directly related to the likelihood of misconduct and violence of all severities inversely. In other words, the older you are, the less likely this is to occur.
Is there any data that supports this finding?
There's extensive data, and I'll illustrate just a few of these. So this is a study that I did with Adipole Cunningham and John Sorensen, where we looked at the relationship of age to prison violence. And on this chart, you see the age of the inmate across the bottom. And then you see on the right hand, on this left hand scale, the rate of violence or the rate of misconduct and infractions of all sorts. Now, one of the things that we've done is we've had to collapse the data. That's what that legend means. When you see times 10, times 20, times 100. In other words, if this was to scale, the graph would be as tall as the ceiling because the likelihood of a disciplinary infraction of some sort is pretty high. Not unusual for an inmate to get a disciplinary infraction in a given year, while the likelihood of an assault with serious injuries is very low. But regardless of the severity, whether you're talking about a ticket for not making your bed or potential violence, all assaults, assaults with injuries, or assaults with serious injuries, the older the individual is, the less likely those misconducts are to occur. The dotted green line reflects where an inmate is at age 34, like this defendant. And so you can see, and of course, as a risk assessment scientist, what I'm most concerned with is that bottom line that goes across. That's the assaults with serious injuries. Those have almost disappeared by the time somebody is 34, and they're going to continue to decline across the lifespan as the person crosses into their 30s. I'm sorry, into their 40s.
Dr. Cunningham, is there other research you've conducted that indicates the relationship between inmate age at admission and the comparative likelihood of serious prison misconduct and violence?
There is. This is another study that we did looking at over 33,000 inmates, the same kind of scale where we got the age of the inmate across the bottom, and then how often this is occurring, the infractions are occurring with the various lines, the different severities on the left. And the dotted blue line reflects where an inmate is who's age 34. And so again, you get a proportional sense of how the inmate who's 34 is less likely to be involved in more serious misconduct than those younger inmates, and how that likelihood continues to decline as the inmate ages. And again, with those serious violent acts being quite low, really for all the groups, but particularly so by the time you get out past 30.
So were these same age-related findings demonstrated in earlier research on state prison inmates?
They were. So this is a study that Hahn did. He based his doctoral dissertation on this. They're looking at a large sample of state prison inmates, same scale, the age of the offender across the bottom, the frequency of physically aggressive infractions on that left side axis, and you see the same curve, that the older the inmate is, the less likely those are to occur. And the dotted blue line reflects where an inmate is at age 34. So you get, again, some comparative or proportional understanding.
So is this same trend demonstrated with inmates who've been convicted of capital murder?
It is. It is. This is a study that Dr. Tom Reedy and Dr. John Sorensen and I did, where we looked at federal capital offenders who were sentenced to life without parole. They were either sentenced to life without parole instead of the death penalty by their capital juries, or after being death penalty charged, they were allowed to plead to life without parole. We then followed them in the Bureau of Prisons, in federal prisons, averaging about 6 years of follow-up on that sentence. Now, admittedly, that's not a lifetime. That's only 6 years. But one of our observations from our data sets is that if an inmate is going to be violent in prison, you tend to see that in the early years of their confinement. And the longer they go without violence, the more of a track record, a pattern they're establishing, the markedly less likely that is to ever occur. And so 6 years is a pretty good test of that time to failure. And again, you see, regardless of the frequency or the severity of the violence, you see how it decreases with age. The green dotted line reflecting where an inmate is who's age 34.
So looking at all these studies, Dr. Cunningham, how does Mr. Burgos-Aviles' age inform the risk of serious violence in prison?
Well, it says that this factor, as we would simply look at his age, and again, it's one of the most powerful factors that we would use in predicting that he is both unlikely to commit serious violence and disproportionately unlikely as compared to the inmates who are younger than he is.
And Dr. Cunningham, have you and your colleagues studied inmates who killed other inmates?
We have.
And
so a subsample that we did, that I did, this is a study with John Sorensen, Dr. Mark Vegan, and S.O. Woods. S.O. Woods at one time, I think, was directing the classification in TDCJ. He's retired from TDCJ. Now, inmate homicides don't happen very often in prison. And so in order to get a set of 35 inmate homicides, we had to study an 8.5-year period of time to get an aggregate of enough to actually understand something. One of the things we looked at is how old were the inmates that were killing other inmates. And then we graph that. And you see the rate per 100,000 inmates and how that declines with age. Again, the green dotted line reflects where Mr. Burgos-Aviles will be at age 34 entering the prison system. By the time an inmate gets to age 50, there were no inmates over age 50 who killed anybody in prison during the 8.5-year period of this study. And of course, even those inmates that were 40 to 49, it's only 1.2 per 100,000. It was extraordinarily infrequent among them as well.
So, Dr. Cunningham, is the conclusion that Mr. Burgos-Aviles' age shows that he has a very low risk of violence in prison in the future?
That's correct.
Now, Dr. Cunningham, can we talk about the next factor supporting your conclusion that Mr. Burgos-Aviles is likely to adjust to a life term in TDCJ without serious violence?
So the next factor is making application of this past pattern approach. To look at what his pattern of behavior has been in custody over 5 years, which is certainly time to have a well-established pattern. And in that period, that 5-year period, he's had one minor disciplinary infraction in 5 years. And that involved water bags being found in a cell search and confiscated. Inmates fill bags of water in order to work out. They use them as weights, grabbing onto the bag of water and doing curls or presses or that kind of thing to exercise. But that's contraband. They're not allowed to have that. And so this was not for anything related to violence, but rather that he had this workout material. And these were not just him. They were confiscated from other inmates on the unit as well.
And did you learn that from your review of the Webb County jail records?
I did. I read the disciplinary infraction about this, including that what was found and that this was found in other inmate cells as well.
And Dr. Cunningham, could you talk about your next factor supporting the conclusion that Mr. Burgos-Aviles is likely to adjust to a life term in TDCJ?
I can. The next factor is education.
And what is the significance of Mr. Burgos-Aviles having graduated from high school and having some college?
Well, this is based on research demonstrating that inmates who've earned a high school diploma or a GED have lower rates of violence in prison. Now, this was a finding that was this particular observation, and there are other studies that have observed this, but this was based on a study of a couple 100,000 inmates in federal prison, a study that Hare and Neil Langan conducted, Miles Hare and Neil Langan, that they observed this in that very large data set. My colleagues and I then examined this in a sample of state prison inmates. And this is a study we did in the Missouri Department of Corrections, looking at inmates that were housed together over a 11-year period of time, as I recall. And this particular prison system, the Potosi unit, is a level 5 facility in Missouri DOC. So inmates are not locked down alone in their cells, but this is a high security institution. This study is remarkable because it includes death sentence inmates as well as inmates that were death eligible and sentenced to life terms, and also other inmates whose offenses were serious enough that they were held at a level 5 facility. Now, the reason how this includes death sentenced inmates is that since 1991, the Missouri Department of Corrections has been mainstreaming their death sentenced inmates. their experience, their institutional experience with these death sentence inmates were that they didn't require all the security and confinement and restrictions that were being applied to them on death row, and spending those resources on those death sentence inmates was depriving the rest of the prison system from officers whose attention was better directed to other inmates. And also you're tying up solitary cells so they're not available to you to put the troublemakers in. So at the request of staff, they began an experiment of mainstreaming their death sentenced inmates, where these inmates were celled with inmates that were non-death, on units that were non-death, out on the yard with other regular inmates, in contact visitation with other inmates and their families. They treated them just like any other inmate they had in custody. They determined the security level based on the inmate's misconduct in prison, not on whether he was under a sentence of death or not. So this was an opportunity to examine those offenders and whether they to gather specific follow-up on whether those death sentenced inmates were more violent in prison or not. And I'll talk about that here in a few minutes, but that's the sample we're talking about. So this is deep into the pool, serious inmates, capital inmates. The table that you're looking at is a logistic regression model. It's this fancy statistical technique. The important number is all the way over on that right-hand column that's labeled EXPB, exponent B. And those are odds ratios. So if an inmate had 12 or more years of education, holding all other factors constant, he was half as likely to be involved in assaultive misconduct as the other inmates he's side by side with in the same facility over an 11-year period of time.
So, Doctor, you're a native Texan. I understand this data is from Missouri. Is that appropriate to use Missouri data to extrapolate to Texas?
Good question. Good question. So in science, one of the issues that we examine is whether findings generalize to other settings, to other individuals. One of the ways that you do that is by doing very large-scale research, as in this case involving thousands of inmates. You also then gather information from other prison systems around the country to see whether your predictive factors hold true in Arizona, in Florida, in Oregon, in Texas. And what we find is that they do, that the same results are replicated in correctional jurisdictions around the country. Now, it makes sense. We would expect they would be replicated, because as I am in prison systems around the United States, I'm always impressed with how similar they are. The architecture of the prisons is similar. Often they're built by the same prison companies. Their security measures, the mix of inmates that are in prison is the same. Their disciplinary policies, the way that they treat infractions, that they belong to the same corrections associations. They're accredited by the same organizations. There is tremendous similarities in the operations of state prison systems nationwide. And in those numbers I talked about, like 16% of inmates in Texas prisons have been convicted of a homicide. Nationwide, that's about 12 to 14%, very similar. In all prison systems, state prisons, over half of the inmates are serving time for a current violent felony. So the mix of who's in prisons is also remarkably consistent from state to state.
And Doctor, what is the next factor supporting your conclusion that Mr. Burgos-Aviles will likely adjust to a life term in TDCJ?
So the next one is his employment history with the military and the Border Patrol. He was in the Navy, did, I think, initial training in the Navy, and then was in the Navy Reserves for a number of years. He has 9 years of employment history with the Border Patrol. Both of those are not only the continuity and stability of that employment, but also as it involves some additional degree of regimentation, authority, that sort of thing, it requires an additional quality of compliance and ability to get along in a highly structured setting. So it has some additional predictive effect from that as well.
So is there a significance of community employment in forecasting prison adjustment?
There is. And this is something that a prison researcher by the name of Quay wrote about 40 years ago and continues to be true today. And that's the observation that inmates who had histories of being gainfully employed in the community, who occupied themselves industriously in the community, as that's a pattern in their life, when they come to prison, they seek to continue to productively and industriously engage. And so these are the inmates that are involved in prison industries and are doing the maintenance in the prisons and working in the kitchen and the laundry, that they are motivated to keep busy and to be industrious, and they tend to promote greater stability and have lower rates of misconduct.
Are there additional inferences that we can gain from Mr. Burgos-Aviles' service in the Navy and the Border Patrol?
I think there are. As I described, I think that demonstrated capability to be adjusted and succeed in a more structured, regimented, authority-based system predicts well for one's ability to do that in prison as well.
And I remember you're a naval veteran as well. Is that correct, sir?
That's correct.
Okay. Now, what is the next factor that supports your conclusion that Mr. Burgos-Aviles will likely adjust to a life term in TDCJ?
So the next factor is continued contact with community members.
And what is the role that continued contact with community members in its relationship to prison adjustment?
This is based on the observation that inmates who are in contact with community members and by telephone, by letter, particularly by visitation, that those inmates have lower rates of violence in prison and misconduct in prison. Probably several reasons for that. Part of it is that there is an incentive that they want to maintain. They're compliant because they want to keep their phone privileges or their visitation privileges. As they have contact with those community members, it keeps them anchored to community values. They don't want the disappointment of getting in trouble, losing their visitation, and now their loved ones have the pains of that as they can't come to see them and are cut off from them. So, and I think it also contributes to inmate mental health and adjustment as well. So for all of those reasons, inmates who are in contact with community members do somewhat better in prison.
And specifically in regards to Mr. Burgos-Aviles, what have you learned about his contact with community members?
Well, he has telephone contact. These are approximately with his father daily, his grandmother daily, and his uncle, spouse, and mother occasionally.
Incorrect.
And he has periodic visitation with his spouse, his father, his mother, a paternal uncle, a paternal aunt, paternal grandmother, and paternal step-grandfather.
And what is the you discussed this briefly, but what is the significance of contact with community members in forecasting prison adjustment?
That as you have this sort of contact, it promotes better inmate adjustment, reduces the incidence of misconduct and violence.
And is there data to support this conclusion?
There is, and I'll simply present one of those studies. This is a study of 2,000 state prison inmates, and they found that disciplinary infractions were infrequent. They had a low base rate, whether the inmate was visited or not. Any visitation reduced the likelihood of misconduct. The inmates that were not visited have 50% more misconducts than those who were consistently visited. And none of the consistently visited inmates were in the high misconduct group. So it illustrates this kind of protective effect that visitation can have.
And Dr. Cunningham, what is the next factor supporting your conclusion that Mr. Burgos-Aviles will likely adjust to a life term in TDCJ?
The next factor is that he has been convicted of capital murder.
Well, that seems the opposite of what we would expect. But so could you explain what that means and what you have studied about prison behavior of capital offenders?
Well, certainly. This was a finding that surprised me when I began to do research about capital inmates and their behavior in prison, but has been redundantly replicated in study after study that we and others have done. And this illustrates the importance in doing risk assessment of not relying on intuitive expectations, but rather relying on science. So for example, if I'm going to rely on my intuition and common sense, when I look out the window, I would tell you that the world is flat. Quite obviously, I'm looking at it, it's flat. Now, that's an intuitive assumption about the earth that to demonstrate that that's not the case actually gets into some science and some math. And so you've got kind of intuition on one side and then scientific data on the other. And so very important as a psychologist is undertaking a violence risk assessment to rely on science and not on intuition. And so let me describe some of that science to you. This is a study that we did on those federal capital inmates that were sentenced to life without parole instead of death, either by their juries or were allowed to plead after being death penalty charged. And these are the guys that we followed for about 6 years. Now, about 20% of them, 1 in 5, were involved in at least a fist fight during those 6 years. The incidence of serious assaults was about 1 in 11. Now, a serious assault is one that has the potential of resulting in more than first aid injury, as the feds define that. Now, look what happens, though, is the severity of the violence increases. Assaults with moderate injuries, that was less than 1% across a 6-year period of time. Now, a moderate injury is one that would send somebody to the hospital. In this group across 6 years, there were no assaults with major injuries, 0. Capital sentence inmates in U.S. penitentiaries, out on the yard, interacting with other inmates, 0 assaults that sent somebody to the hospital with a life-threatening injury, 0 homicides, 0 serious staff assaults. Now, we examined then their likelihood of being involved in violence as compared to the 18,000 U.S. penitentiary inmates they were side by side with, and found that being convicted of a capital murder did not increase their risk across any of these metrics.
So, Doctor, this isn't on my script, but I want to show I'm paying attention. Would that earlier Missouri example that you gave where they put death row inmates into the general population, would that also support this data conclusion?
That would, and let me skip ahead to that. Actually, we're going to get to that, but let me just say yes. The capital offenders in that Missouri group that are mainstreamed and are side by side with the ones sentenced to life and other inmates in that prison system, they're not segregated on death row. The life without the death row, the death sentenced inmates look just like the guys that are serving life without parole. Those two groups were half as likely to be involved in serious misconduct as the parole eligible inmates they were side by side with in the same facility over the same 11 years.
I apologize, Doctor. I'll stick to the script. Is this, Judge, is this a good time to take a break? My computer is about to, I just got a low battery note, so I can get the plug and
Saved by the
continue.
computer.
I
We
just
got a
didn't
low
know it,
battery
but
note from
if there
William
one.
Boggs' laptop. It's like, is it a good time for a break?
I know that
It's
you got long to
4:35
go.
p.m.
It's like you're page 50. And I do know, however, that you did tell me that Dr. Cunningham needed to take a break, so I'll allow Dr. Cunningham, the witness, to take a break so that, and while that time occurs, you can take advantage of that and perhaps plug in your computer in the many outlets available throughout the courtroom. Okay,
Thank you, Your Honor.
so let's do that. I'm gonna take it down, your camera.
Oh, Goma one says, Gisela, we see your knowing and sympathetic glances at us. To the jury who watched the replay one day. So sorry.
Okay, thank you.
To
And
everyone here, thank you.
and we'll be right back. I'm gonna try not to get off of here, so we'll see what happens.
I'm
Go
going
ahead.
to try not to get off of
Who's
here.
right, who's jury?
What happened? Okay, so if the judge says, I'm going to try not to get off of here, we'll see what happens. What does that mean? And we have a hot mic right now. Hot mic, hot mic. Oh, we still got some coffee time. Welcome, Sue. Please, Judge, please, please, wrap it up. I'm so sorry, Judge. could feel your pain too. And it's 4:35 p.m. I told you, we're going to be all night, and by all night, I mean it's almost midnight my time again. Oh, yes, indeed. Mary Kay says you all make this bearable. Yes, you do. Rona's like, take a break, WTF, go home, please. He is home. Remember, the witness is home. And click off the Zoom meeting. We're on page, what was it, 52? Was it 54? Oh, my word, out of 80.
Risk assessment standpoint, the greatest concern is with injuries that would send somebody to the hospital, whether serious or severe meaning life-threatening or fatal. And among this group in 15 years, 1% of them committed an assault resulting in inpatient serious injury. That means 99% did not. None of them assaulted somebody that sent them to the hospital with a life-threatening injury. There was one fatal attack in the group.
And Doctor, have you or your colleagues studied even another state prison behavior of convicted capital murders?
We have. This was looking at inmates in Arizona who'd been sentenced to death, then got relief from that sentence, and end up in the general prison population. Now, we focused in this instance on those that had gotten relief from their sentences so that they're not locked down on a death row unit that would further inhibit or hold them at a higher level of security, instead where they were interacting and in the general prison population. And among these inmates, the rates of, or the prevalence rates of assaults involve a minority. 16% committed a serious assault, 3.8% an assault with great bodily injury, and there were 2 murders that were in this group of 80 former death sentenced inmates.
And do you have the Arizona Department of Corrections disciplinary infraction codes?
I do, so if there were any questions about exactly what was involved in those are reflected on slide 57.
Now, Dr. Cunningham, have you or your colleagues conducted research on violence among other capital defenders who are sentenced to life terms?
We have. So this is a study of 111 Texas offenders who were initially sentenced to death. And they were sentenced to death under the current sentencing scheme, which includes that their juries answered yes to the question whether there's a probability the defendant would commit criminal acts of violence that would constitute a continuing threat to society. They answered yes to that special issue. This 111 offenders were sentenced to death. They then got relief from those death sentences because of errors that had happened in their sentencing proceedings. They had averaged almost 10 years on death row and about 8.5 years in the broader prison population. So lots of opportunity to be violent. These are guys that had been in prison for an average of about 18 years. So if they were going to be violent, lots of opportunity to exhibit that.
And what were your findings?
Again, we've got the array of misconduct from least serious to most serious. And as you can see in terms of other inmates, about 40%, about 4 out of 10 were involved in at least a mutual fist fight. And 3.6% were involved in an assault against a staff member that resulted in more than first aid injury. As we look at the totals for this, including both assaults against officers and other inmates, that involved a total of 48% of the inmates. Just less than half of them were involved in an assault or fight of some kind. But only 1 in 11, only 8%, in an assault that resulted in more than first aid injury. None of them perpetrated a major or life-threatening injury assault, something that sent somebody to the hospital with major injuries, life-threatening injuries. None of them killed anybody else during those 18 years averaging in prison. And so even among capital offenders who had been predicted to be violent by their capital juries, when they got to prison, you only have 8% of them across 18 years, about 1 in 12, who committed even a serious injury assault, and nothing that was life-threatening.
So, Dr. Cunningham, did you do research in Florida as well as Texas?
We did, this time looking at whether having been convicted of first-degree murder was predictive of violence in prison, or whether these offenders were more at risk. And in this study, we looked at 5,000 inmates who'd been convicted of first-degree murder. We looked at the whole prison population, all 51,000, and among those were 11,000 who were convicted of property offenses. So that's the offense of conviction, that's the first column. Now the next column is total disciplinary infractions for anything. And so in the year that we were studying them, about 1 in 3, 35%, got a disciplinary ticket for something among the first-degree murderers. But see, that's about 20% less than the general inmates are getting, and is well below that of the property offenders. So the first takeaway is, while they get disciplinary tickets, the murderers do, they don't get them as often as the other inmates. When we look at potentially violent misconduct that includes any assault and weapons contraband and that sort of thing, again, the first-degree murderers are about 20% better than the other inmates. Once we get out to assaults with injuries, or assaults with serious injuries, they look just like the other guys they're in prison with. So that conviction for first-degree murder was not associated with greater misconduct or greater violence. The other thing that you see in this is, notice how as the severity increases, its likelihood dramatically decreases. So about 1 in 3 get a disciplinary ticket for something in a given year, if we're talking about our murderers. but only 1 in 500 are involved in an assault with serious injury.
And doctor, are these published findings?
They are. So these findings were published in a leading criminology journal, Crime and Delinquency.
Now, Dr. Cunningham, I believe you referenced that the more serious the prison violence, the less likely is to occur. Do the findings of this study illustrate that conclusion?
They do. In all of the groups, including the first-degree murderers, you'll notice that as the severity of the misconduct increases, its incident dramatically decreases. That's why it's important in doing a violence risk assessment to specify the severity of violence that you're concerned with. And so we publish these data, breaking it out along these severity lines to best inform other corrections researchers and folks involved in public policy about what sorts of assaults are happening in prison and how often they occur.
And does other research confirm this counterintuitive finding that homicide offenders are not more violent in prison?
There is. This is a study that compared homicide offenders, those are the yellow bars, with property offenders, those are the deep purple, assault offenders, they're the medium purple, and robbery, those convicted of robbery, in the light purple. And whether you're talking about serious violations or assaultive violations or serious assaultive violations, the homicide offenders are not disproportionately represented. And in some categories, have both in the serious violations and assaultive violations generally have a lower incidence of that.
Dr. Cunningham, could you describe your next factor supporting the conclusion that Mr. Burgos-Aviles is likely to adjust to a life term in TDCJ?
So the next factor is that he will be serving a life sentence, if not sentenced to death.
And describe the findings that support that conclusion that inmates serving a life without parole sentence are likely to have a nonviolent adjustment to prison.
So this is that study that we did on the Potosi unit in Missouri, where we looked at 2,600 inmates in this high security prison, and over an 11-year period of time examined how inmates sentenced to life without parole compared to the parole eligible inmates they were side by side with. And we found that holding other factors constant, those serving life without parole were about half as likely to be involved in assaultive misconduct as the parole eligible inmates they were side by side with. In other words, the incentive of parole someday doesn't seem to be driving how inmates behave in prison.
So, Doctor, did you and your colleagues conduct any follow-up research with this sample?
We did. So we then looked at this group again on the Potosi unit and our mainstream death sentenced inmates and life without parole inmates, this time looking at them over a 25-year period of time instead of an 11-year period of time. And in this one, we found that the mainstream death sentenced inmates and the life without parole inmates were about the same as the other inmates. They all had a lower level of violence, and identified that part of what had changed in terms of that earlier study is in the earlier study, some of the inmates that were sentenced, that were serving assigned to the Potosi unit, got there by getting in trouble in prison. And so by their misconduct, they had ratcheted up their security level to the Potosi unit. Now they're bad actors, they're on the Potosi unit. When those offenders who were getting in trouble a lot were spread through the other units at that security level, now the overall incidence of violence in the facility dropped, and what sentence somebody was serving didn't make any difference.
So, Doctor, is there data that would persuade us that this finding about life without parole inmates have good prison adjustments sound?
There is. So we replicated this. This is in Missouri. And so then we looked at another sample in this time in Florida. and we looked at 9,000 long-term inmates. We looked at about 1,900 that were serving life without parole, almost 2,000 that were going to be serving 30 years or more, and 5,000 that were serving sentences of 10 to 29 years. So we got 9,000 inmates in total. As we look at those LWOP, those inmates sentenced to life without parole, across the 6-year period of time of this study, less than 0.5%, only 1 in 200, committed a serious injury assault out of those life without parole inmates. This study demonstrated that inmates serving 30 plus years in prison or even life without parole were not a disproportionate risk of prison violence.
So, Doctor, let me ask you, I mean, that seems to be counter to what we would expect, because most people say someone who's doing life without parole have nothing left to lose. Is there an explanation as to this counterintuitive finding?
There is, and it also illustrates kind of the fallacy of trying to apply your common sense to this. Common sense would say, okay, so if you're already serving life without parole, what are they going to do to this guy? He'll be unmanageable in prison. He has nothing to lose. Now, when we actually look at life without parole inmates, though, study their disciplinary records and also interview them, what we discover is that the life without parole inmates have more to lose rather than less to lose, or nothing to lose. And here's what I mean by that. So, if you're in prison and you're only serving 3 or 4 years, and they lock you down in your cell, they take away your commissary, then okay, that's fine, I'll endure that hardship. But if this is where you're going to be for the rest of your life, now those small incentives, the ability to purchase a can of beans and a package of potato chips when you're eating institutional food day in and day out for decades, that becomes a very important privilege. You can be a bad actor and spend the next 30 years in a walk-in closet, or you can comply and go along with the program and stay out of trouble and come out and have a job to do and have some sense of industriousness and help the time pass and interact with other inmates. And so the longer somebody's going to be in prison, the more important those small incentives become. They're particularly motivated not to make this experience any more horrible on themselves than it has to be.
And this helps to explain why life-sentenced inmates actually make better prisoners?
That's correct.
Now, do you have a model that would help explain why offenders who are at such risk for violence in the community have low rates of serious violence in prison?
I do. So, the factors that were involved in somebody being violent in the open community, we can essentially think about those as being like weights on a scale. And what happens in prison is whatever the risk factors were that led to this violence in prison, they are substantially counterbalanced and incapacitated by security and structure and staff and confinement and immediate application of consequences in terms of breaking a rule and then having your privileges taken away. And so that security, structure, staff, confinement, consequences, those counterbalance the risk factors that were resulting in these individuals being violent in the community.
Could you please summarize these base rate findings regarding prison violence?
So first, capital inmates have very low rates of violence when they're in the general prison population. The rates of serious violence among capital inmates are extremely low. The more severe the projected violence, the increasingly remote its occurrence is actually going to be. The seriousness of the offense that sent the person to prison does not predict prison violence. And the older the inmate, and this really begins across their 30s, the lower the rate of disciplinary misconduct and violence. And so as we project Mr. Burgos-Aviles, it isn't, there's a lower rate just by virtue of being 34. And then across the next decades, that risk will fall further.
So relative to these group rates, what factors would we use to individualize these numbers to Mr. Burgos-Aviles?
So relative to the group rates, I found no factors in this case that would serve to raise him above those low base rates. There are a number of factors, though, that serve to reduce his risk.
What do you mean by relative to base rates?
So that's what I was describing earlier. So let's say the base rate for serious violence is 7-8%. And we have a factor that increased the risk by 30%. Well, that wouldn't mean he's more likely than not, even if it were present, because 30% means that the risk is now 11%. Even if we had a factor that doubled the risk, we'd go from 8% to 16%. That means 84% still would not, even with that risk factor. So as you apply a risk factor, it means that you keep that anchored to that group rate. The more you stray from the base rate, the more likely you are to be in error. So unless you have very compelling research-grounded reasons to stray from the base rate, as you do so, it's speculative and you're moving toward error.
Well, could you help us understand what factors would increase his risk as compared to the group rates you've described?
Sure. So if he were 20 years old, that would be a significant factor raising his risk relative to the group rates. If he were a member of a prison gang, depending on the study, if there were a robbery or burglary associated with the capital offense. If he had a history, very significantly, if he had a history of recurrent violence in custody, that would be a major factor to raise his risk relative to the group rates.
And what factors would reduce his risk compared to the low base rate of violence among capital offenders?
Well, those that I've identified, age 34, one minor disciplinary infraction in 5 years, this history of disciplinary compliance and nonviolence, education, military and border patrol employment, continued contact with the community, those would all reduce his risk. I mean, even correctional appraisal, even as Mr. Fitzpatrick talked about him being at G3 and that they wouldn't send him to administrative segregation. That's its own judgment that in full knowledge of the offense that he's committed and his history, that he would not go to administrative segregation. So that's its own statement that upon taking custody of him, they don't regard him as a disproportionate risk of violence.
And do you integrate all these factors into your professional judgment and experience?
I do.
So, Doctor, what's the next factor supporting your conclusion that Mr. Burgos-Aviles is likely to adjust to a life term in TDCJ?
So the next factor are actuarial comparisons. That's like our 16-year-old male unmarried driver, of grouping characteristics about him and then looking at what impact that has on the frequency of prison violence.
So, Doctor, what are the statistical approaches that could also be applied in integrating factors specific to Mr. Burgos-Aviles?
So the first thing that we could do is look at him in comparison to all inmates. So he's going to be an inmate in prison. How does he compare the characteristics about him to everybody else who's an inmate in prison? So that's the first set of comparisons. So there's an actuarial model that we can apply that is based on 13,000 offenders admitted to the Florida prison system, and we are then reviewing their disciplinary infractions the next year. And based on risk characteristics about him, he would fall into the lowest 8% of risk. In other words, 92% of those incoming inmates are more likely to be involved in prison violence than he is. He's in the lowest 8% of risk. in his risk group at 8%, there was a 3.8 incidence of potentially violent misconduct. So about 4%, or about one guy in 25.
And the actuarial model is the same model that's used by insurance companies?
That's correct. They're doing the same thing. They're identifying risk-relevant characteristics, studying their group of individuals like that, like 16-year-old male and married drivers, and identifying the risk by integrating those features.
And Dr. Cunningham, in addition to the actuarial model based on all inmates, do you have data that takes specific features of Mr. Burgos-Aviles and examines how inmates with those features compare to other inmates?
I do. So for example, we can take this all inmates and compare it to matched murderers in prison. So this is a sample that is based on 20,000 inmates who served time between 1 and 12 years. And our match group, the group that we're matching to Mr. Burgos-Aviles, are murderers who are age 33 or older with no prior arrest record. So those are the risk-relevant features that we're going to use. So how do those guys, how do murderers age 33 or older with no prior arrest record, there were 75 of those, how do they compare to the other 20,000 guys they're in prison with? And here's what they look like. Now, in these bar graphs, the red bars, of course, don't represent Mr. Burgos-Aviles. He wasn't a part of this study, but they represent the inmates, the matched group of murderers, and how they compare. And so the blue bars reflect all inmates in terms of level 1 violations. The red bar on the left reflects this matched group. And the same thing as we move next to the assaults, that the blue bar is the frequency that this is happening among all inmates as compared to those that match characteristics of this defendant. So you can see there is a disproportionate less likelihood.
Dr. Cunningham, could you define what a level 1 violation means?
I can. So a level 1 violation is a physical injury to staff, tossing bodily fluid, a serious injury to an inmate, injury by a weapon, a threat against the institution, refusal to halt an attack, having sex while HIV positive. Those are all level 1 infractions.
What does assault violations mean?
So that's any assault that is from level 1 to 4, and I'd have to turn to another source to give you more information. That's the full range of assaults.
Well, in this data, what does serious violent acts mean?
So serious violent acts are a hostage, a sexual assault, a physical injury to staff, serious injury to an inmate, or injury by weapon.
Now, Doctor, what is the next group of actuarial models and comparisons that can be applied to Mr. Burgos-Aviles?
The next would be to compare inmates on high security units. In other words, he will go to a higher security unit. So rather than looking at everybody coming into prison, let's do comparisons between inmates matching his characteristics and other inmates on high security units, like where he'll be.
And what are the results of that modeling?
So the first group that we can look at are 24,000 inmates that are classified in high security or close custody. Now, they aren't locked down in their cells all the time. They're coming out on the units and yards, and they're double celled and that kind of thing. They're just in secure perimeter facilities. It's called close custody. And the match group that we're going to compare to all of these guys on close custody are those convicted of first-degree murder, sentenced to life without possibility of parole, who are age 31 or older, who are not affiliated with a prison gang, who have an above average educational equivalency test. The test is at a 9th grade or above level. Of course, having a high school diploma in some college would also reflect this, and having no prior prison sentence. So those are the risk relevant characteristics that we're able to extract from this group to compare with everybody else who's in high security.
And how does Mr. Burgos-Aviles compare?
So the inmates sharing his characteristics are those that are in the violet color. So the base rate is the rate among the total of the 24,000. The violet is the incidence among those inmates matching his characteristics, and there were 169 of those. And so whether we're talking about potential violence or assaults, the inmates, these matched murderers, have a lower rate. And then when we get out to looking at injurious assaults, those did not occur at all among these matched murderers, as compared, and you see they're infrequent among that population in high security, but they are occurring.
And do you have another comparison that can be applied to Mr. Burgos-Aviles?
I do. So this time we're looking at just over 18,000 inmates that are confined in maximum security prisons, like where G3 inmates are held. And our comparison group is looking at inmates convicted of murder, serving life without parole, who are age 31 or older at intake, and are educationally prepared, meaning they have a GED, a high school diploma, or more. So that's our comparison group of offenders sharing characteristics with this defendant.
And how do inmates with risk features in common with Mr. Burgos-Aviles compare to other inmates who they are side by side with?
So those matching his characteristics are in purple, and those that are the maximum security inmates who they're side by side with are in this kind of Nile green color. And so whether we're talking about potential violence or minor assaults or major assaults, you can see that those sharing the risk characteristics with Mr. Burgos-Aviles only have a fraction of the rate of the inmates they're side by side with. And are also particularly unlikely. So under major assaults, that rate is 5.4 per 1,000 inmates per year.
And
so that's 5 per 1,000. It's 1/9 the rate, 1/8, 1/9 the rate of the inmates they're side by side with.
And Doctor, is this data based on the Missouri experiment that you discussed earlier, where they mainstreamed the death row inmates?
This one is not out of, well, it's not precisely the study that we were talking about before, but it's related to it. This is the follow-up study based on the 25 years. It's not the initial one.
Well, Doctor, how many murders or manslaughters, attempted murders or hostage restraints or forcible sexual assaults occurred during those 25 years?
Actually, that's this is 18,000. That's actually looking at this next study.
Okay.
This one is based on the Missouri data that I had described earlier. This is the 25-year follow-up of that Missouri data.
I'm not good on script. I apologize.
No worries.
Could you describe the comparison that you're showing now, sir?
Certainly. So among these, so we looked at almost 3,800 male inmates in this maximum security prison in the Potosi Correctional Center. And among those, we have 196 that are match comparisons. And those are inmates that were convicted of murder. They're serving life without parole. They're age 33 or older when they come into prison, and they don't have any prior criminal convictions. And the average follow-up for this comparison is 5.7 years, 5.5 years. And then here's how they did. The inmates in general, among these 3,800 inmates, those are this Nile green, and those matching the characteristics of this defendant are in the purple. And again, whether we're talking about potential violence or minor assaults or major assaults, those sharing these match characteristics with this defendant have lower rates than the inmates that they are side by side with in the same facility over the same decades.
And now I'm going to ask you, during the course of this 25-year experience with mainstreaming, with capital punishment inmates, how many murders, manslaughters, attempted murders, hostage restraints, or forcible sexual assaults?
So in 25 years, there were 0 among that group. Didn't happen.
And then, Doctor, what's the next set of actuarial models and comparisons that can be applied to Mr. Burgos-Aviles?
The next are comparisons with capital murderers serving life without parole.
And please describe the first actuarial model that can be applied to Mr. Burgos-Aviles.
So the first one is follow-up on 136 Texas capital murderers. We're defining violence as dangerous rule violations. And the predictors are various personal characteristics, criminal history, and offense-related variables that emerged out of the actuarial model.
And what predictive factors were specified in the logistical regression analysis for this actuarial model, which could be applied to Mr. Burgos-Aviles?
So what emerged as predictive factors from this group of 136 offenders was either age less than 21, age 21 through 35, or age greater than 35. Whether they had a prior prison commitment, and whether there was a contemporaneous robbery or burglary in the capital offense. So again, we took our logistic regression table and we created what's called a Burgos scale, which is a simplified risk rating, averaging scale, where you get points for greater risk and you subtract points for factors that are associated with lesser risk. So in this, there's one neutral factor, which is an age greater than 35. The other factors are risk elevating features.
And what is the basis for this weighting factor that you're showing us?
So the basis of this is the underlying logistic regression analysis. And research demonstrates that you can take those very specific decimal point related weightings, turn them into a simpler numerical model, what's called a Burgos scale of simple adding numbers, that performs equivalent with a much more complicated formula of integrating those various odds ratios from the logistic regression analysis.
And what does this study tell us about Mr. Burgos-Aviles' likelihood of continued acts of violence in prison?
Well, he would trigger the age 21 through 35, which would add 1 point. So his total risk points are +1. So then we look at the outcomes of the offenders in those groups. So we had 3 levels of risk. We had level 1 if you had 0 to 1 point, level 2 if you had 2 points, and level 3 if you had 3 points. And you can see that as those risk points increase, so does the incidence of misconduct. So among those that are in his risk group, as we move out here to assaults and assaults with serious injuries, of those 136, none of them committed assaultive violations. None of them committed assaults with serious injuries. 10% of them engaged in potentially violent misconduct. That may have been a threat or something that was construed as a weapon, but no assaults with serious injuries.
Is there another comparison which could assist us in confirming your assessment of the level of violence posed by Mr. Burgos-Aviles compared to other capital inmates sentenced to life?
There is. This is another study out of Texas looking at almost 2,000 capital murderers and drawn from a more recent data set in fiscal year 2008. And the match comparison group are 339 inmates, a larger comparison group as well. And those comparisons are with male inmates 31 and older, convicted of capital murder, with an above average educational equivalency of above 9th grade, no confirmed security threat group affiliation. Security threat group is a fancy word for prison gangs, and no prior prison sentence. So that's our match comparison group of 339 as compared to the other capital murderers. And here's what they look like. So the blue bars reflect the rates of this violence or potential violence among the almost 2,000 capital inmates in general. And the red bars represent those inmates with characteristics matching Mr. Burgos-Aviles. And again, we're looking at three gradations: potential violence, assaultive infractions, and injurious assaults. And not only is the frequency of these very low, but those matching the characteristics that he has are disproportionately less likely.
Now, I feel like we're piling on, but are there other studies that support these assertions?
Yeah, you're piling on, for sure.
There are. This time we're going to look at disciplinary infractions among a group of federal life without parole inmates. And in this instance, we're going to compare them, the life without parole inmates, to those in U.S. penitentiaries, and and compare the rates of those. And those life without parole inmates are actually not much different than the inmates they're side by side with. Their rates of assault with moderate injuries are lower numerically in terms of the annual rate, but it's not statistically significant. So life without parole was not associated with a nothing to lose kind of behavior. And the frequency rates in U.S. penitentiaries, high security, and among these offenders, once we get up to assaults with moderate injuries or above, is very unusual, very rare.
So, Doctor, did you look at a subgroup that matches a feature of Mr. Burgos-Aviles?
We did.
And
so this is only those who are over age 33 at entrance to prison. That was the only matching feature that we could draw.
What if there's 100?
And how did those over the age of 33 at entrance into prison compare to other life without parole inmates they are side by side with in the same prisons?
So that light blue-green is the base rate among these other guys they're in prison with. The purple is the rate per 1,000 inmates of these different severities of violence. And again, those who are 33 or older sharing that characteristic are much less likely to be involved in violent misconduct, however you define it.
And Doctor, what's the next set of actuarial models and comparisons that can be applied to Mr. Burgos-Aviles?
Well, the next group that we could look at are capital murderers who were sentenced to death and then granted relief.
What's the relevance of this sample to Mr. Burgos-Aviles?
Because this is the deep end of the capital inmate pool. These are inmates that were not only capitally charged, but they were sentenced to death And not only were they sentenced to death, they were predicted to be seriously violent in the future. And so this is the deep end. So how does he compare to this deeper end of the capital offender pool?
Could you describe the actuarial model for this group?
I can. So in our first one, this is a sample of 80 inmates, former death row inmates, and that then got relief and are followed in the general prison population for an average of 13 years. And the predictors are age, time served, and prior behavior. And so our Burgos scale looks like this. Those were the risk variables that emerged out of the logistic regression analysis. And the features that will apply to him are in the green bars, that he is age 25 through 45, and he will be serving more than 5 years.
And Doctor, you called it the Burgos scale. It's not the Burgos scale, is that correct?
That's correct.
Okay.
Burgos, Burgess.
Okay. I think you speak Spanish like I do.
I think that, and that's not at all. I apologize.
Doctor, what does this study tell us about Mr. Burgos-Aviles' likelihood of continued acts of violence in prison?
Well, as we would apply this actuarial model to him, he would be in the level 1 group, and their rate of any assaultive violations was 18 per 1,000. The incidence of assaults with serious injuries is 11.4 per 1,000. And you can see how much less likely the capital offenders are at his risk level as compared with the other inmates they're side by side with, the other capital offenders in Arizona prisons.
And have you and your research colleagues published any other actuarial models for assessing violence risk of capital defendants?
We have, and I need to amend my prior testimony. So this particular group was not assessed on the special issue. They were sentenced to death and got relief. So in terms of being sentenced to death, they're the deep end of the pool, but Arizona does not have the special issue. I had not anticipated what slide was next. So this is Arizona, sentenced to death, but doesn't involve the special issue. The Texas study that we did is both sentenced to death and sentenced to death under the special issue. And this involves, I've talked about this study earlier, 110 capital offenders who are averaging about 18 years in prison.
And what are Mr. Burgos-Aviles' risk factors according to this study?
So again, making application of the logistic regression analysis that emerged out of this to create a Burgos scale, his age being greater than 31 subtracts risk. His having normal or high intellectual functioning subtracts a point. The fact that there were multiple victims doesn't add or subtract. It's irrelevant to the risk among these offenders.
So what is I'm sorry.
Go ahead.
What does this study tell us about Mr. Burgos-Aviles' likelihood of continued acts of violence in prison that would constitute a continuing threat to society?
That it is both unlikely and also that he is disproportionately unlikely as compared to other capital offenders in Texas prisons to commit violence. So he's at level 1, he's in the lowest risk group. In that group, about 1 in 3 were involved in an assaultive violation, at least a mutual fist fight. But very importantly for our proportionality analysis, there were no assaults with serious injuries in that level 1 group of capital offenders across 18 years in prison. 0.
So do I understand you correctly that both of your actuarial models for capital murders relieved of a death sentence place Mr. Burgos-Aviles in the lowest of the 3 risk categories, with none of those offenders in those categories perpetuating serious violence in prison?
That's correct.
Now, Dr. Cunningham, Some people might object that your comparisons don't address offenders who murdered multiple victims in a domestic homicide context like Mr. Burgos-Aviles is convicted. Could you address that specific comparison?
And so we can also examine offenders killing multiple victims in a domestic homicide. So we're going to look again at these capital offenders who got relief from their death sentences in Texas. Remember, sentenced to death, got relief. Now, of those offenders, 1 in 3 had multiple victims. Having multiple victims was not associated with an increased risk of prison violence. So a substantial portion of this pool had multiple victims. That was not a predictive factor, having killed more than one person.
So, Dr. Cunningham, have you done other research which demonstrates that multiple victims factor is not predictive of prison violence?
I have. So this is a sample looking at 145 male life without parole inmates and extracting from that the group of murderers with multiple victims. And here's what they look like. So across these columns, you have single victim homicides across the top, what the disciplinary infraction was, then single victim homicides, multiple victim homicides, and whether there was a statistically significant difference between them. And what emerges is that while the numbers for those with the multiple homicides look lower across all categories, they're not statistically significantly lower. So the takeaway from this is whether killing more than one person is not associated with a greater incidence of prison misconduct, regardless of the severity we're examining.
So, Doctor, do you have data that compares homicide offenders killing multiple victims in a domestic context?
I do. So this is a sample of almost 14,000 TDCJ inmates. This is in Texas, convicted of homicide. And we're looking at them in June of 2012. Now, they have served anywhere from a third of a year to 33 years. The mean time they've served is 8 years. Our matched comparison group that we've taken out of this larger body of 14,000 inmates convicted of homicide are inmates convicted of killing multiple victims during a domestic encounter. And here's how they compare. The blue bars are the general homicide offenders. The red bars are the intimate partner homicides with multiple victims. And again, whether you're talking about level 1 or assaultive or injurious assaults, those with multiple victims are not disproportionately represented. Now, in two categories, level 1 and assaultive, they only have a fraction of the rate of the other homicide offenders. The injurious assaults are extremely infrequent for both groups. And now they're the same as the other homicide offenders they're side by side with.
Now, Doctor, what's the next factor supporting your conclusion that Mr. Burgos-Aviles is likely to adjust to a life term in TDCJ?
The last factor is special custody in TDCJ.
Now, we discussed this a little bit earlier, but why do you believe Mr. Burgos-Aviles may be in a special custody unit?
It is standard procedure in state prisons and federal prisons nationwide to place former law enforcement on specific units as opposed to just dropping them into the general population regardless of their prior employment status. And the reason for that is that former law enforcement tends to be targeted by other inmates in prison. And the prison systems have a primary agenda of housing these inmates within prison so they don't leave, and maintaining low rates of violence on other inmates and on staff. And so it just makes sense that, knowing the additional risk that these individuals are under, that you would then assign them to units where that risk is mitigated. So they're assigned to units where there are other law enforcement, or where there are sex offenders, because sex offenders are also targeted in a general prison population. And so they may not be put in protective custody, or in Texas what's called safekeeping, but that doesn't mean that they aren't assigned to units that will reduce the likelihood of violence occurring. Those units containing sex offenders and law enforcement officers, those units have lower rates of assault than you see in the general prison population. And that makes sense. A lot of prison violence is perpetrated by gang members, and that's not going to be present in this context. And also, these individuals have incentives to want to remain in that kind of unit, as opposed to being locked down in ADSEG, which would be the next step to protect them.
Doctor, it sounds like you're saying, and have said, and we're about halfway through, that TDCJ does a good job generally in preventing prison violence. Would that be fair to say?
They are very effective. I wouldn't just say that it would be fair to say they do a good job. They are very effective, particularly when you think, again, of that mix of inmates who have come into their custody and how low the rate of serious violence is in Texas prisons. They are very effective at their job.
And Doctor, could you, you touched on it, but could you describe the inmates that are at a higher risk of victimization? What does TDCJ have as specially designated housing units for those who require it?
All right, so there is a specific unit on TDCJ that is called Safekeeping Unit. It's a relatively small unit. It has, well, as of a week ago, week and a half ago, there were 66 inmates on that protective custody, on that, well, it's protective safekeeping. They call it safekeeping now rather than protective custody. Now that's 66 out of 122,000. So this is a very particular unit that they might put somebody on who they thought was especially at risk, had particular vulnerabilities. Again, that doesn't mean that they aren't engaging in assignments and classifications to other units that may be grouped with particular offenders. This is just the protective safekeeping numbers. And to illustrate how low the rates of violence are on these specialized units, in this protective safekeeping unit in 2022, there were no serious staff assaults, and there were no serious inmate assaults, period.
So, Doctor, are there mechanisms that TDCJ uses to control disruptive or violent inmates?
There are. So prison systems always act dynamically. In other words, they're always learning from inmate behavior. They're studying they're observing the inmates that are in their charge, identifying who needs additional services or how to respond to misconduct. And so they're responding dynamically to the needs that inmates present for greater security or treatment. And so among the available measures to respond dynamically to inmates that are engaged in misconduct, there's treatment. If their misconduct is emerging out of psychological disorders, there's counseling and medication and education. There's the stick side of things, which is cell restrictions, loss of privileges like visitation, commissary, jobs, recreation. They can fine you, take your property, put you in administrative segregation, solitary confinement as a punishment. So they can apply that discipline. They can also extend privileges and incentives through those small inducements that are so powerful in prison. And then if an inmate demonstrates that he needs greater security and restriction, then they're going to ratchet up his classification. And that may ultimately include placing him in administrative segregation. Now, they can't simply lock him up and throw away the key. They have to have periodic reviews. But again, they will be responding dynamically based on their experience for how long this offender needs to remain in administrative segregation in order to secure institutional safety.
So, Dr. Cunningham, in light of all the data that you have analyzed in relation to Mr. Burgos-Aviles, what is your conclusion about his probability of committing criminal acts of violence that would constitute a continuing threat to society?
Well, it's my opinion that he is quite unlikely to commit serious violence in TDCJ, and further that he's less likely to commit serious violence in prison than other inmates in general and other capital offenders.
Now, you brought us a lot of data today. Has anyone used this data and scientific method in other matters?
They have.
Okay, and could you describe some of them?
Sure. So I think this was in 2004, 2005. I testified about these data, and particularly regarding the seriousness of the offense and prison misconduct and life without parole inmates, and whether they were a disproportionate risk of violence, as the Texas legislature was considering whether to change the death penalty statute in Texas.
So, give me a second, sir.
Yes,
There's an
yes.
objection.
Go, prosecution.
Approach the.
Approach, object, say this is burkaka. What is going on here? That is ridiculous. It's TMI, the poor jury. Oh my word. No, Mr. Boggs. Shame on you. It's too much. Seriously, bring your bullet points and that's enough. Right? Like, you want to drive this point right home. Like where? What? Based on what? KK says, if she hasn't objected yet, I've lost all faith. The ADA will say, no questions. I mean, what in the freaking... Okay. Remain calm. It's 6 o'clock Texas time. It's freaking 1 a.m. for me. And we're still going? This day, every day, feels like, could it get worse? This was the worst trial day so far. This was terrible. Yes, Judge. Tell us. There's no audio. Burgos, you enjoying that, huh?
Dr. Cunningham, has the state ever asked you to testify about the issue of prison violence?
They have not. They have not asked me to present this data.
And I believe you were saying that the state, have you testified in the legislature about it?
Well, yes, sir. So in 2004, 2005, the Texas legislature was considering changing...
One second, sir.
Sorry.
Yes, ma'am.
Objection, relevance,
It's,
and bolstering.
it's an expert. His qualifications are relevant to the jury's evaluation of his opinion.
Overruled, so.
Jury, please strike this witness.
So the state of Texas, so this legislature was considering whether to change the sentencing scheme that occurred in capital trials. Up to that time, the alternatives available to the jury were either a death sentence or a capital life term. That capital life sentence had evolved over time until ultimately it was 40 years to serve.
One second.
Again, Your Honor,
All right.
objection, relevance.
Not sure that I want the legislative historical perspective. I don't mind him saying, as he testified, that he testified in general on these issues to the committees, our legislature. I just don't think we need to go into the details of the legislative history and all the potential legislative bills, which we know that obviously there are thousands and thousands of bills that are filed every year, and only a few actually get to it.
So, Doctor, could you hear the judge's ruling?
I did.
Okay, so, but you have testified before the Texas State Legislature, is that correct?
That's correct, describing how inmates who were sentenced to life without parole were not more violent in prison than.
Go ahead.
And that legislation then passed the Texas legislature, changing the statute from 40 years to life without parole. The research that I've described, I testified about that. It was distributed in a fact sheet to the legislature, and it was ultimately signed into law. The sponsors of that bill credited this data on life without parole inmates and the relationship of sentence length and seriousness of sentence to prison behavior. They credited the presentation of that research to the change in Texas law.
Now, Doctor, you mentioned earlier, I believe, a couple of hours ago, that you'd written a textbook. Is that correct?
That's correct.
And
so
tell us about that textbook.
Sorry. Thank you. I'm sorry to interrupt.
No.
So the textbook was part of a series of forensic psychology textbooks published by Oxford University Press. And there is a volume, there are like 18 volumes in this series, each one of them about a different area of forensic practice. Child custody, mental state at time of offense, competency to stand trial, personal injury, that kind of thing. And in each case, the leading experts in the country were asked to write the text on best practices for that type of evaluation. I was asked to write the textbook on best practices in capital sentencing evaluations. And that was then published by Oxford University Press. So that's the textbook that's on my CV.
And Doctor, has your research been cited in any Supreme Court of the United States cases?
It has. A paper that I co-authored was cited by the U.S. Supreme Court as authority in a case called Moore v. Texas that looked at criteria for finding persons to be intellectually disabled in capital sentencing, another area of interest of mine.
Okay. I'd pass the witness.
All right, thank you. Approach.
Yes,
Please.
Approach, please. Pass the witness, please, for freaking... That's really... Boggs, what is your strategy? It's too much. It's too much. He's going to be a really good boy in LWOP, and he'll be a really bad boy in death row. Like, okay, you made your point on slide 1. That was, I don't know, it's just... That was too much. Amber Gloria, thank you so much for your $5 super sticker. It's just, you know, you got to respect everybody's time, especially the juries. There's no strategy in that. It's just too much. You know, you're just trying to overwhelm them.
Obviously, Mr. Boggs was kidding about he's halfway through. And so it's 6 o'clock. We could go for another another hour, easy or more. There's a lot of data. There's a lot of questions. So we're going to allow you to take a break. I don't think your brain is, you know, where it was at 9 o'clock this morning because of the time of day and because of the type of information that you received. So let's take a break, and we will be back in the morning at the same time. Remember the instructions that I've given you from the very beginning. We're trying to get through. There are some delays, and I apologize for them. I'm trying to shorten them as much as possible, but sometimes
Every time.
the fairness of the system and justice calls that we do this, and you all are at the receiving end of that, unfortunately. But I appreciate your patience, your time, and your effort. So thank you, and have a good evening. No, tomorrow 8:45. We start at 8:45. Yes, not at 10.
Please rise to the jury.
No, you won't. We know. Maybe 9:30. Maybe 9:30. You guys.
Thank you for reminding me
The
of that.
Haglin, welcome. Elsa, thank you so much. No, man, that was just too much. Judge got exasperated, says Anonymous, with pros for playing extra minutes of Burgos interrogation video. Yes, but no exasperation from the judge on putting his foot down. He's going way too soft on the defense team. Because having the boundary and saying just no, like the same thing, exactly. Like you can't play those extra minutes of the Burgos interrogation. Really? You got to go through that? Why? So that the the defense team can have all the time in the world? No, I just don't think it's fair. There must be a time limit on this stuff, because it's just, man, I feel sorry for the jury. Kimberly, you don't guys, would you recommend that Kimberly rewinds and watches this? I wouldn't really do that. That was hectic. We made it, says Peter Pronzo. You know, Lieutenant Peter Pronzo knows. He's been here from day one. Triple A Energizer Bunny over here, right? But this is pushing me to my limit. This is like, oh my word. I'm not really a hang around and wait kind of person as it is. I'm like full throttle, go. You guys know I'm like bullet points, presentation, let's go. This is like dragging out. But man, Boggs, oh my gosh, you just annoyed me today. If I was on the jury, okay, I'm expressing this because maybe the jury feels the same way of like, that was so annoying. And they're going to continue tomorrow. With the same witness. And that will be, he didn't pass the witness now, right? Mr. Boggs said he's about halfway. Oh my word, about halfway. So it probably is 188 pages of this ridiculous presentation with outdated information. It just is. MCTD Mama, I'm a prior CO, correctional officer in Idaho. Our lifers were the most well-behaved because it's their forever home. But who cares? He earned the death penalty. Thank you so much. Yeah, that's the thing. Who cares, right? Even if it's like he'll be so well-behaved there, he's going to be so well-behaved. We don't care. We want justice. We don't care if he's going to be a good little boy and get his freaking beans and potato chips, right? We just want justice. Okay, let me make this stream public. What? Marie Chaldenes says Boggs was fantastic. What? Oh, did he? Did he pass the witness? Thank goodness. Okay, wait, this is going off now. Shame, cameraman. Bye. Bye, cameraman. Have a nice night. See you tomorrow. Wow. Let's take this text off quickly. Bam. Okay. He passed. Okay, you guys are like, he passed. Passed the witness. Thank you. I just couldn't even remember if he did or not. I was so excited when it's like, yes. Break time. Okay, so tomorrow's stream is set. Oh my God. Thank you all so much. Please like, share. Thank you for making Grizzly True Crime trend on Twitter. That was sweet. Thank you so much. It's because you guys are liking and sharing. And why do we want to do that? Please let more people know about this case. Let them come over. Let them watch this guy get sentenced. I cannot wait. I don't care what the outcome is. Just let him get sentenced. Let him be in his little prison outfit and off you go. Because actually either way is bad for him. Terrible for him, and that's what we want. Okay. I'm going to make this stream lead to the next one, okay? Are you ready for tomorrow's stream or what? Because I'm ready. I'm going to first turn off slow mode. Wait, did we already turn it off? Almost. I'm going to turn off slow mode, yes. And I'm going to redirect you guys to the next stream. Sorry, earlier you guys were like, where? We lost. Some of you were there. Some of you were like, I don't know where it is. Sorry about that. Saved. Off we go. Let's hope tomorrow the defense rests their case. Let's hope tomorrow closing arguments in the afternoon. That'll be amazing. Let's hope then the jury deliberates or what? Jury instructions? Jury deliberates. Maybe they come back on Friday. Oh my word. That'll be like, wow, what a celebration. I think the whole of Laredo, Texas. The whole world at this point, all of us here will celebrate. You're like, damn, is she talking in her sleep now? Yeah. Okay, so this stream will lead you to the next one. If you can't find it, just go to my homepage, or I'll put it in the description box after the stream ends. And forgive me for not doing the timestamps right now. I always try. It's very hard for me to go to sleep. I still have normally about 45 minutes to an hour of work, but it's 1:20 in the morning, so I'll try. Okay, bye everyone.